Can you take that down for a sec?
Yes, sir.
I just want to make sure everything's working and then just unshare.
Yes, sir.
All right, so we've got podium, clear touch. We don't have a bunch of things aren't connected. That one's not connected. I'll connect the jury one. Are we good with this screen? Great. So jury.
When Mindy's up, we just want to show maybe about 40 seconds of the officer's body cam to show the initial interaction.
Assuming he's not leaving.
The officer was there between Monique and Sir. About 40 seconds.
All right, so we have podium, clear touch, defendant, got jury now. We need that one. Do you want me to add that or you're adding it?
I'm still gonna need you to add it. Yes. Having some sort of network issue.
Let's see, prosecutor. Yeah, it won't let me launch the controller. This happened last time.
I just quit it.
You fixed it?
It should work now, yeah. We'll give it a second.
Okay.
Okay.
No, it's not letting me launch the controller. It'd be great if we could sort this out before 9 o'clock each day. Well, while that's happening, Ms. Rivers, are you ready? Okay. Mr. Jordan, are you ready? I don't know how many jurors we've got. We got all of them? Okay, you can check in a sec. We can get rolling because Mr. Higginsbottom is up. Are you ready for Mr. Higginsbottom to come out?
Yes, Your Honor, the state is ready.
Okay, Ms. Feely?
Yes, sir.
Great, if we could bring Mr. Higginsbottom out, please. All the jurors are here.
Good morning, Your Honor. How are
Good
you?
morning, Mr. Higginsbottom. All right, we're going to go on the record in 23 SC 186187, State versus Curtis Higginsbottom. Mr. Higginsbottom is in the courtroom. He sounds rejuvenated. He is surrounded by his lawyers. We've got two prosecutors. Mr. Jordan, anything we need to cover from the state before we bring the jurors in?
Your Honor, the two pending matters, which are I believe that Your Honor was going to give it till this morning for Ms. Feely in regards to Investigator Harding.
Yep, I'm going to ask her when I get to her.
Yes, Your Honor. And well, there's no matters for the state, but I just wanted to bring back to Your Honor's attention the first matter and also the matter of if there were any other parts of the interview that needed to be redacted, which Ms. Feely has already told us personally this morning, but I'll defer to her.
Okay, there was only one that was identified yesterday, but Ms. Feely said she was going to be watching the interview again. The one that was identified related to Serenity Mathis's reference to Mr. Higginsbottom appearing high at the time of the August 31 incident. But I think we had agreed that there was a pretty clear stop point, and then we would mute or fast forward, and then there was a start point where then Ms. Mathis was referring to Mr. Higginsbottom's eyes being low, consistent with some trial testimony, and we could go forward from there. Have those stop and start points been identified and shared with Ms. Feely?
Yes, Your Honor. And the remedy that the state came up with was to actually clip that part out where drugs are referenced. We did show that to Ms. Feely this morning. I believe that's in accordance with Your Honor's ruling.
Okay.
In regards to that.
Great. Then I'll be sure to tell the jurors before you press play that the video has been edited because of some discussions about things that weren't relevant to the trial. So they shouldn't get suspicious if it seems choppy.
Yes, Your Honor.
Okay. Ms. Feely, let's start with the video because we're on that now. Were there other areas that you felt needed to be redacted upon further reflection?
No.
And have you had a chance to see what the video is like with the redaction of the reference to Mr. Higginsbottom being high?
Yes.
You're okay with it?
Yes.
Great. Okay. Let's talk about Investigator Harding.
So it seems like I'm not going to be able to call her.
Okay, for the reasons we discussed.
Right. I couldn't appeals couldn't come up with a creative solution around that. So.
Well, that's telling because they're very creative. So, all right. So it sounds like then the discussion we'll have when the state rests, I'll have with Mr. Higginsbottom about whether he wants to testify. That would be your witness if he chooses to testify. Okay, got it. I want to get one thing on the record, and then anything you want to get on the record, Ms. Feely, concerning Mr. Higginsbottom's well-being and his care at the jail. And so I'm going to swear in Deputy Gordon and just have him answer a couple questions on the record so we make a record about it rather than me just saying it. And then either side's free to ask Deputy Gordon questions only about that topic. And then, like I said, if there's anything more, either side wants to get on the record. So Deputy Gordon, if you'd raise your right hand, you promise to give truthful answers to all questions posed during your examination. Okay. Did you accompany Mr. Higginsbottom back to the county jail yesterday?
Yes.
Before then, while Mr. Higginsbottom was still in the courthouse, but in a detention area, did you observe him eating his lunch?
Lunch?
Or food of some sort?
No.
No? Okay. You accompanied him to the jail. Did you go with Mr. Higginsbottom to the medical area of the jail? And while there, did you observe some medical professional dispense to Mr. Higginsbottom his prescribed medication that we had discussed in court? And did he take that medication? Okay. And then did you take steps to ensure that Mr. Higginsbottom also got dinner last night? Did you watch him eat it, or you just made sure he was going to get dinner? Okay, thank you. Mr. Jordan, do you have any questions for Deputy Gordon in this area?
No questions from the state.
Ms. Feely?
Yeah.
All right, thank you, sir. Mr. Higginsbottom, I'm not putting you under oath because no one can make you testify, but I would like to know if, one, you got the medication.
Oh, yes.
Okay. Two, you got dinner.
Yes.
3, breakfast?
Yes.
We're on a roll. Did you get your morning medication?
No, they tried to give me milk of magnesia. I don't know why.
Okay,
I take that only on the weekend.
okay.
You know,
And you declined that, but
I declined the milk of magnesia, of course.
got it. But the important one, the Seroquel that you did not get 2 nights ago, you got yesterday.
I've gotten that and Benadryl
Okay, good.
and the one for anxiety.
Excellent. All right. I find from my non-medical professional observations that Mr. Higginsbottom is in a much better state of mind, consistent with the state of mind he was in on Monday when we picked a jury, and Tuesday, our first day of evidence. And I'm prepared to move forward. Last chance, Mr. Jordan, anything else before we bring the jurors in?
No, Your Honor.
Okay, Ms. Feely?
No.
All right. When the state rests, the jurors will get a break. We'll handle motions for directed verdict. And then I'm going to put up on the screen real briefly. I found it's not so new. I don't know how it didn't get scooped up and incorporated, but the new plain language versions of child molestation and aggravated child molestation. It's just the elements, but they're broken out in numbers. So it's sort of in chunks. So the jurors see, oh, we need to find this, and this. But I'll share that with you all. It's nothing controversial. It's just going to look a little different than the format before. And otherwise, I cleaned up the jury charge consistent with what we discussed. And given the redaction to the video, I have excluded the voluntary intoxication charge.
Yes, Your Honor.
Okay, let's bring the jurors in. Are we good with the prosecutor? You just leave? Now I can add it? Okay, let's see. He says, yeah. Let me try one more time. I refresh that. It's looking good. I'll let you know if it doesn't work.
Okay.
All right, Mr. Jurors.
So for future reference, it's helpful if you fill in all the way while you're walking in, so someone doesn't have to squeeze by you all. Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen.
Good morning.
Thanks for being here. We are ready to continue with the state's case. Add that additional light. Here. We didn't cover much of the state's case yesterday, so we left off wherever you remember us leaving off, at the close of business Tuesday, and here we are Thursday morning. I'm going to ask the state to call its next witness.
Your Honor, the state calls Charity Olaka to stand. Raise your hand. You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good Lord, and have a seat. You state and swear your name for the record.
My name is Charity Olacha, Charity. Last name Olacha, Olocha.
Good morning, Ms. Alacha. How are you?
Good morning. I'm good.
Good. Can you please, where are you currently employed?
So I'm employed full-time at ChildKind, which is a child placement agency.
Can you explain what ChildKind is?
So ChildKind is a child placement agency where I recruit and train foster parents. It is where you would get trained as a foster parent, and we will put children from DFACS into your home.
Where did you work before ChildKind?
So before ChildKind, I've been at ChildKind since 2018 of September, but I was still actually working full-time there and at Georgia Center as well.
What can you explain? What is the Georgia Center that you just described?
So the Georgia Center is a nonprofit agency where they conduct forensic interviews. They also have a therapy center there as well. They also have a family advocacy department where they help children in the community. They also have a department in the agency where they help children who have problematic sexual behaviors.
And what is the full title of the Georgia Center?
I'm sorry, it's a Georgia Center for Child Advocacy.
And did you have any other employment before the Georgia Center for Child Advocacy involving children?
Yes. Previously, before I worked at Georgia Center for Child Advocacy, I worked at the Division of Family and Children Services in Fulton County.
And can you describe what is your educational background?
I have a bachelor's degree in social work from Georgia State University, and I have a master's degree from Columbia University in New York, and I am a licensed master social worker. I got the licensed master social worker in August of last year.
And what was your position at the Georgia Center for Child Advocacy?
Forensic interviewer.
And did you have any training related to that?
Yes. So we went through a week-long 40-hour training in South Georgia, and the training was called Child's First.
And when you worked there, how many forensic interviews did you conduct?
Between 80 and 100 trainings. 80 and 100 interviews.
Is there any other interviews that you observed?
Yes.
How did those come into play?
So those came to play prior to my Child First training. I observed the interviews. I wanted to kind of understand exactly what I was doing and what I needed to actually see from law enforcement side and also the forensic interview side. And then when I went to Child First training, after I came back from the Child First training, I wanted to actually apply what I learned from the training to the actual interview itself. So I was sitting on the interviews in the observation room with the detectives and some of the other trained interviewers and actually see for myself what I was learning from the protocol and actually see how they were applying the actual knowledge that I learned from the trainings. So yes.
Did you ever, did you ever have the opportunity to conduct a forensic interview of Serenity Mathis?
Yes.
And when did that interview take place?
September 19th of 2022.
And where did it take place?
At the Georgia Center for Child Advocacy in Fulton.
Can you describe in terms of where at the center was the interview?
In the observation room?
Yes. Can you describe how the observation room is set up?
Oh yeah, it's just an observation room, very general thing, white walls, green carpet, and it's a cabinet in there, and there's some dolls, anatomical dolls in the cabinet, but we don't let the children see it, obviously. And it's just a chair, 2 tables, it's a camera, and we point that camera out, and then it's a mic, not like this, but it's a mic on the wall.
And who was present during the interview?
Me, Serenity, and then the observation of Detective Blair, but he is behind the camera, so you don't see Detective Blair, but the Serenity, it was notified that he's observing us.
And is that interview recorded?
Yes, sir.
Your Honor, the state is approaching handing the witness State's Exhibit 24. And what is State's Exhibit 24?
This is my interview with Serenity,
And how do you recognize it?
my initials and the date.
Is it a fair and accurate representation of the interview you did with Serenity?
Yes.
Your Honor, the state moves at this time to admit State's Exhibit 24.
Ms. Feely, any objection to the admission of States 24?
No, Your Honor.
It's admitted.
Your Honor, the state is going to publish State's Exhibit 24.
Ladies and gentlemen, in a moment, you will be watching and listening to the interview that you just heard about. I need to let you know that because of some discussions I had with the lawyers, a little piece has been redacted. So partway through, it may seem herky-jerky, like it skipped. It did skip because there's a piece that's not relevant to what you all need to consider. Don't think that the state has spliced something and tried to slip it by you. They didn't slip it by me. They didn't slip it by the defense. That's the byproduct of a discussion we had when you were enjoying whatever you did yesterday afternoon other than being here.
Thank you, Your Honor.
And hopefully the state has figured out how to make it audible.
Yes, Your Honor.
We'll see.
And Your Honor, for the record, the state's going to start around 1 minute and 18 seconds when they enter the room.
Sorry about that. Trash can right? How you doing today? Good? Yeah, I can have a seat. It's a little chilly. So you doing good? Okay. Charity? I appreciate it. So my job is to talk to kids and teens and sometime adults when something may or may not have happened, but really my job is to get to know you. Okay? So that's how I asked you in the beginning, like, is your name Serenity? And you was like, yes. So if I ask you a question you don't know, you can tell me you don't know. Question, and you may not understand that it's all kind of bad. You can tell me you understand, okay? Or if I ask you a question and you forgot to answer it, okay, remember you can tell me. I still want to take gas while we talk today. All right. So take a look around the room. You got any questions? Does something pop out to you at all? It's two cameras. Perfect. Okay, I did want you to see those two cameras. And so behind those two cameras, the second player is observing us and know what we talk about. Okay, so I'm just telling you the truth. So why we talking to you? I'm telling you the truth. Why we talking to you? I'm telling you the truth. Yeah. Okay. So I make sure I feel like I'm in court. You feel like you're in court? You're not in court. I know a little bit. I feel like it. Tell me how come you say that? Because when I say nothing but the truth. Okay. Well, I want to make sure while we talk today, we tell each other the truth. Okay. But this is not court. You're not in trouble today. Okay. We're just gonna talk. All right. Okay. Just a little bit. Say your name for me. S-E-R-Y-N-I-T-I. Okay. And that's Serenity. Is that right? And what's your last name? Mathis. M-A-T-H-I-S. M-A-T-H-I-S. Okay. And how old are you? 13. You're 13. And when's your birthday? July the 9th. 7909. 7909. So you had a birthday recently. You do anything for it? Skating. You were bowling. Okay, so tell me everything about that, your birthday. How did you woke up on your birthday? The time you went to bed on your birthday. Well, it was actually fun. Like on my birthday, it was raining. So I slept in a little bit. Okay. Not like all the way through my birthday, but I woke up and I was like, it's raining. And I was like, man, I really want to do something on my birthday, but the next day I got something. Well, the next day after my birthday, I went skating and bowling. Okay, the day after your birthday, you went skating and bowling. Okay. Yeah. Well, on your actual birthday, what did you do? I stayed home Okay. I stayed home. Stayed home. I stayed home and I listened to music and I got edibles. It's like chocolate thing. Chocolate thing? They're like fruit, edibles, flower thing. Oh, okay. Yeah, okay. The fruit arrangement, I get that right? Okay. Okay. I got that for my birthday and then I got cards. Okay. And who got you the fruit arrangement? My cousin. Your cousin? What's your cousin's name? Dajane. Dajane. How old is she? She's old is she? She's 25. I think 25, I believe. Yeah. Okay. I believe it's 25. Okay. So after your arrangement, then you get your edibles. And then what happens? Take the pictures of what? I mean, like take pictures of my edibles and okay. What'd you do next? I listened to music and just chilled, and then the next day I went out like bowling and skating and having fun. Okay. And who did you go with? My sister. Your sister? What's her name? Antoinette Maxis. Antoinette Maxis. And my auntie. What's her name? Monique Maxis. Monique Maxis. Okay. And so you said you guys went bowling and skating. And how did you guys get there? Bus. Okay. And so tell me about when you went bowling. It was fun. I was really nervous for like skating because I skated before. Okay. It was fun. Okay. And what about bowling? Bowling, I was trying to get the the white thing. I don't know the name of it. So like when you roll the ball, it's like white. And like it hits them. Okay, so what are you talking about? Just bowling. Bowling. Okay. Yeah. And yeah, it was really fun that day. It was fun. Okay. Alright. Serenity. Are you in school today? Like in general, are you in school? What school you go to? Crawford Law Middle School. Crawford Law Middle School. And what grade are you in? Seventh grade. You like being in seventh grade? You like about it? It's been really fun. What's fun about it? Is that I don't know, don't want to talk about it. No. It's just like fun. Like school to me, I don't like school, but I know I have to go. School is hard. Because I know it's like you enjoy. Okay. Okay. And there's some tissue right there, okay? So tell me, how come you're crying? Happy tears? The happy tears. Okay. It's some tissue right there, if you want. Charity. Charity, my bad. It's okay. My name is Charity. Miss Charity. Did you call me Charity or Miss Charity? Okay. Whatever makes you feel. Miss Charity. Like when I started like high school, like I visioned just like happy tears, so envisioning graduating from high school caused you to have happy tears. Am I getting that right? I'm getting my diploma. Okay. Okay. So I can do it. You think that you can do it? I can do it. Okay. 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 Give me a minute. You take a couple deep breaths. I'm okay. You okay? All right. So right now, 7th grade is fun. You get that right? You having a good time? Kinda. Okay. Okay. I got you. So Serena, do you live in a house, apartment, or something? I live in a house. Live in a house? And who lives in that house with you? My aunt. Your aunt? What's her name? Monique Maxis. Monique Maxis. Okay. Who else? That's it. You live in a house with you and your aunt? Okay. Do you and your aunt do things together? We just like chill and like go out sometimes. Okay. What do you guys do when you go out? We like go to the mall. We talk. I talk to her. You talk to her? Okay. So go to the mall, chill, and then I'll talk to her. Maybe like sometimes, not all the time. Okay. And like go like grocery shopping. Okay. Okay. And Miss Cherry, how can I say this? My uncle, Curtis Higginsbottom, he visit us sometimes, like, okay, come and go. Right? And I want to tell my aunt, and I finally told her, Curtis Higginsbottom. One night, I was sleeping. I'm a very light sleeper. Okay. And I really slipped up to my room, and he said, he called me by my nickname, and he said, Dog, are you asleep? I said, you know people sleep. Okay, yeah. I was like laying down, feel like all of us, I was like this. And he was touching my butt. And he touched my private part. Like, no, like on top, like it's like a little it's on my private part. It's up, and he whispered in my ear. I'm here. Is that my favorite person to wear? He said to have private flight. Did you say anything else? He whispered in your ear. You said go to the underwear. I'm sorry. You said go to the underwear. He told you to put on your underwear. What happened? I got a couple questions, okay? And like I said before, oh, go ahead. One more time. Higginsbottom. Higginsbottom. Bottom. Okay. You said that's your uncle. Well, can I say Curtis Higginsbottom? Sure. Okay. Okay. He on my private part. You said he spit on your private part? Did I hear that right? Okay. And he was going in circles. You said you was going in circles? He calm. He was going in circles, he was gonna make you cry. He said it's gonna make you calm. It's gonna make you cry. Okay. And what was going in circles? I don't know. Okay, did it feel like anything that was going in circles on your body? Okay, okay, okay. Wait, not really inside my body, but he on it. They put his finger in your private part on it. Is that right? On top of it. On top of it. Okay. And so I do want to say this during the that everybody has different like definitions of private part. So I want to know your vagina. Okay. You say you put his finger on top of your vagina, but not really in your vagina, just on top of it. That's what I'm trying to get in. Like I understand, okay? I wasn't there. So I want to just go over what you told me, okay? Okay. All right. I'll get all of this off my chest. Okay. Go for it. Everything. You have been doing this to me since I was younger. And I've been wanting to tell my aunt. So you said younger. What's younger? Like, for example, when I was like, I believe, I don't know the age, but I was like young, like when I was younger. Okay. I believe like 7 or 6. 7 or 6. Yeah. Do you know what school you were going to when it started happening? Cleveland Avenue Elementary. Cleveland Avenue Elementary. That's when it started happening when you were just going to that school. Not at the school, but like every time when my aunt was like, am I in trouble? No. Well, we talked that you're not in trouble. Okay? You're not in trouble at all. That's when it makes sure I'm asking what happened because I wasn't there. Okay? If it doesn't been since I was younger, and he said, don't tell mommy, he'll be our own secret. And if he tell her, she says, okay. Did he say who would be mad? My aunt. Your aunt? Okay. I know you said mommy, so I wasn't sure if it's, do you call your aunt mommy sometimes? Mm-hmm. So I'm trying to know. Miss Marie. Oh, okay. Okay. Is there anything else that you wanted to talk about? I know you told me there was one more thing, but a whole bunch of stuff that I did to get off my chest. Okay. Chastity. Charity. It's okay. Charity. But no. social worker when I was talking to her that day. I mean, his eyebrows like, he kind of like rolled your eyes and kind of. No, like his eyes a little low, like a little, not like a lot low, but like a little low. Okay. And he was next to me. And what was he doing to you? Okay. Has that happened one time, more than one time, or something else? More than one time. More than one time? Maybe like sometimes. Maybe doing this to me since I was younger. Okay. And what about when he would put you on your butt? Was that one time, more than one time? More than one time. More than one time. Mm-hmm. Can you tell me more about how he would put your butt? He would like smack it. Okay, he would smack it. Okay, and how would your clothes be when you would do that? My clothes? Your clothes. What do you mean? Meaning like, would your clothes be on, off, or something else? On. Okay, your clothes would be on. Yeah. Okay. Would your clothes be on when you would touch your butt, or something else? It would be on. Okay. Okay, so when he had touch your butt, when you touch your butt on top of your clothes, underneath your clothes, or something else? Underneath my clothes. So you touch your butt underneath your clothes? Okay. And he rubbed my and you rubbed your boobs that night? That night. Okay. Do you know what night that you're talking about? This was on this was this is this month. September? Mm-hmm. I get that right? Mm-hmm. That happened this month, September? Mm-hmm. Okay. That was on a Thursday. And that's when I finally told Mommy what happened. Okay. Okay. So when you told me that you would touch your private part, which you indicated was the vagina, and you touch your private part on top of your private part. Is that right? Okay. Like, you know, like I'm gonna say this. I am still in our health class or not. So you feel like you're in health class, but you're not? Mm-hmm. Okay. A little bit. Okay. Well, you're definitely not in health class. I know. You're definitely not in trouble. I know. I want to make sure I know what happens, okay? And make sure it makes sense. So from what you told me is that he's touched your vagina more than one time. Yeah. Did I get that part right? Okay. And how would your clothes be when you would touch your clothes would be on? He would like put his hand underneath my clothes. Okay. And under your clothes. And under your clothes. Okay. And then you told me that he is actually spit on your vagina, which is a little spit on your private part. And he said going in circles. He didn't say that. Okay. But he was like going like in circles, like with his head. Okay. Thank you. I appreciate that. Yeah. So his hand will go in circles. Mm-hmm. And is that on your private part or something else? On my private part. Okay. And how would that make you feel when that happens? Someone did that to me. To me before. But I've been wanting to turn movies, so I wanted to turn around. Okay. So, Lenny, what made it okay this time to tell her? I see that you're crying. You want to talk about it? Okay, let's talk about it. Tell me how come you're crying. Really? Traffic, it's okay. I know, I'm here, I share these. So. Can I finish these? What's in here? Yes, you told me. Okay. Here's the word. So good. Okay. Okay, what's that in your ear? Has it happened one time or the one time or something else already? Well, sure. I know you told me that he will whisper in your ear. Is that part right? Has that happened one time, more than one time, or something else? One time. Okay, that's when you said those things. Okay, okay. I know you had told me once before that you been wanting to tell your Aunt Monique. So tell me how come it was okay to tell your Aunt Monique? I just told her. Okay. What made it okay for you to tell your Aunt Monique what was happening? She was like, it's not your fault. It's not my fault. I just feel relieved and I told her. Okay. And when did you tell her? I told her the night after it happened. Okay. The next day. The next day? Okay. And what made you tell her the next day what happened? I actually told the school and then her. Okay. Okay. And what made you tell the school and then her? I didn't mean to tell the school, the students, they don't know. It's just like the principal knows. But the whole time school don't know. It's just, okay. But what was it that made you tell at the school? Like what made it okay to talk about what happened at school? Okay. Okay. But I'm gonna tell her. Okay. And how did your aunt find out? From the school. From the school? Okay. Did she say anything to you when she found out what happened? Mm-hmm. What did she say? She said, it's not your fault. I knew. Okay, she said not your fault and then she knew? She said what she knew? Okay. Did you ask her what she knew? She said that she knew it was going on because she heard, because my aunt was like in the next room. Okay. In my room. Okay. She said, that's not your fault and that she knew. And can you tell me more about how she knew? You don't know? Okay. 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 I know we talked about what happened with Curtis Higginsbottom. But now I want to ask you, where were you when he had touched you on your butt? In your room. Do you know the address to the room that you're talking about? My room in my house. The room in your house is the way you say it now? I stay with my sister. Oh, okay. Okay. So the house that you're talking about when he touched you on your butt, do you know the address?
The address to my house. Well, I feel my sister now.
Okay. But where it happened at when he touched you on your butt, do you know what the address is to that place? It's your aunt's house? Is that right? Okay. Okay.
Is my aunt gonna get in trouble?
Not to my knowledge.
Oh, can I still be Curtis?
Well, what I can answer is that the detective is here, okay? So if you have questions pertaining to what we talked about who may not get in trouble, you can definitely ask them. How's that sound? Okay? All right. So I know you told me that, you touched on your butt more than one time, you can close that unmarked house. Okay, and where were you when you had touched on your private part?
In my room.
Your room? Okay, and where is that room at?
Next to, like, for example, it's like my aunt room's right here. And then I'm right here, and then there's the bathroom.
Okay, so your room is beside your aunt's room, am I getting that right? Okay, and it happened at Aunt Monique's house, when you took in the private part, more than one time? Okay. And where were you when you said you had spilled your private part?
In my room.
In your room? Okay. I know you said it happened since you maybe 6 or 7 years old.
When I was younger.
When you were younger. Okay. I know you told me what happened at Monique's house. Did it happen anywhere else? Okay. Has something different happened besides the touching on your private part in your butt?
Chastity.
Charity.
Charity. They call you.
It's okay. You don't have to put this, just say my name. Charity.
Charity. He showed me his private part.
Okay.
Penis.
Okay. And where did he show that to you?
In my room more than one time.
Okay. Was there anything on his penis when he showed it to you? Okay. Where were what did he say anything to you before he showed you his penis? Did he I'm sorry. Did he say anything to you before he showed you his penis? Okay. Did he say anything to you while he was showing you his penis?
No.
Okay. And did he say anything to you after he was showing you his penis?
So, Charity. Am I going to jail?
No. I know we had talked earlier about, I know you asked would you get in trouble and you're not gonna get in trouble or something, okay? And you're not in trouble. How come you asked if you won't go to jail? So that you don't, is it that you don't know, you don't wanna talk about it or something?
I'm telling the truth, and that's about the truth. I am.
Okay.
Because I know when I tell the truth, and I know when I lie.
Okay. How come you asked if you go to jail?
Okay.
But for anything, you're not in trouble, okay? I just wanna know what happened. Okay?
And this Charity, he did whisper in my ear, and he did touch my private parts on top of it. And when the circles and spit on it.
Okay. I just wanna make sure I clarify, make sure I get a clear understanding. I hate to touch your private part, but I talk to you close or leave you close like that.
And I'm very like a light sleeper.
Okay,
You know, people sleep.
yes,
I'm a very like light sleeper.
okay. Okay. And so, what made him stop touching your private part?
He was going like back and forth from my room.
Okay. And where would, I know you told me you lived with your aunt. Where would she be when you would come into your room?
She would be like sleep.
Okay.
This happened more than once.
Okay. Do you know like what time you would come into your room?
That night,
That night or any other night? We can start with that night.
okay. I was sleeping, I was very like sleeper. That was around like almost to like 12 in the morning, almost like 11 something.
Is that when you were into your room or something else?
Something else.
Okay.
It's like 11 something, I believe, or like 10-ish. So like curfew is like 9:30. And that's when he said, "Randolph, are you sleep?" I said,
He said Randolph. I get the right Randolph. That's your nickname. I need to get you. And he called you your nickname.
Well, can I just say a nickname? I don't have to say it.
Yeah, you can say your nickname.
My nickname.
And he said, ask where you sleep.
I said, "Huh?" And then that's when he was sitting on my bed. And I was laying down. And he pressed my thought. And underneath my t-shirt, it started feeling on my breath. Like rubbing me.
Okay. Went under your shirt and started touching on your breast.
That's when he whispered in my ear. That's when he said, "Take off my underwear." And he would like force me to take off my underwear.
He said you was pulling them down. Okay.
And then his finger. Over through
Okay. Okay. What made you stop?
baby, you're 13.
So, Randy, I'm gonna take a small break, okay? So you can, have the first respect, okay? I'll be right back. But while I'm gone, if you wanna draw or write out anything else, or you have text you, or just, I can, all right? If not, you don't have to. Okay? I'm gonna be right back. If you wanna just draw a color or doodle, you can. For different colors, I'm good for you, okay? This texting. Anywhere you want. Okay. So what happened after that? This one, with all of it. Like, getting up, and that's when he left. So you heard your aunt getting up, and that's when he left? Oh. And then the next day, I told my aunt what happened. I couldn't take his bottom. I've been doing this to me more than once. I know you also told me he had to show his pants. I get that right. How many times, did it happen one time? More than one time? More than one time. More than one time? Anything happened to his pants? But anything like be on his pants, on his pants? Will you say anything to you as he's showing you his pants? Tell me, please. I wanted to tell Money for you, not like a long time. I wanted to tell her, and I finally told her. Okay. But I do want to talk about, I know that he would make you do something. What would he make you do? Yes, Cassidy. And he would make me see something. That make you suck it? Would anything be on it? Okay, would anything come from it? Is that I don't know, don't want to say, or something else? I don't know. Okay. Do you see anything on it? Like something like clear. Okay. Something clear. Anything else besides clear? That's it. Okay. Okay. Where would you keep the clear at? Okay. And what would make him stop having you to touch his private part? I didn't touch it, he would make me. Right, what would make him stop having you, like, make you touch it? When we came to the door. Okay. Like, if you would like hear her come to the door, if you're going to say something I was on Okay.
And I wanted to tell her, and I finally told her,
Okay. Thank you, but she knew. Did she say how she knew? How come she knew?
I don't know.
Okay. And so I know he showed you his private part more than one time, but you also said he had made you such his private part. Has that happened one time, more than one time, or something else?
One time,
Happened one time? Okay, and where were you when he made you do that to him?
in my room,
Do you remember how old you were?
when I was like younger,
Okay, you were younger when that happened. Okay, do you remember how old you were when you touched your private part?
I was like younger,
You were younger? Okay, and what about when you touched your butt? Do you remember how old you were?
younger and now,
Younger and now. Okay. And what about when you sit on your private part? You know how old you were then?
now,
Now,
people doing it now,
at 13?
that night.
Okay, that night. And then do you remember how old you were when you had last touched your private part?
What do you mean?
I know you told me that you were 13 when he had been in your private part, is that right? What about when he had touched your private part? How old were you then?
I was like, and then he started touching me.
I know you told me you were younger when you started touching your private part, is that right? Okay. How old were you when you stopped touching your private part?
And when I told Monique,
That's when you stopped? And how old were you? You told her.
13,
Okay. Okay. All right. Renee, I'm gonna take a small break, okay? I'll be right back, okay?
right, going,
Just across the hall, but I won't be long, okay? But you can doodle, draw color, or not, it's up to you, okay? All right.
Ladies and gentlemen, I discussed with the lawyers that there's a break right now while Ms. Olocha is talking with someone outside the room. Rather than have us watch silence for a bunch of minutes, the prosecutors would jump to the point at which someone returns to the room.
All right. I told you I wasn't gonna be too long, huh? What you drawing? Trying to stars. Trying to some stars? Okay, you can keep doing it. I've got a couple more questions. We'll go get your auntie get ready. Is your auntie out front?
that's a sister,
Your sister, what's her name?
Antoinette,
Antoinette? Okay. How old is she? 26. Okay, all right. I know we talked a lot about Curtis and Higginsbottom. That's a lot, right? I know you told me that sometimes he'll come over to your aunt's house.
like visit.
Like he'll visit. Was there a reason why he was visiting? Visiting. Okay. And how long have you been knowing Curtis?
My whole life,
The whole life? Okay. Are there some things you like about Curtis? What are those?
my uncle, he's like funny. He even laugh sometimes.
Okay, it's pretty funny. Sometimes. Okay. Everything you do not like about your uncle?
I don't like when he's like, okay. I don't like when my uncle's like, ever since when I was younger, when he told me that don't tell Monique or she's gonna get mad.
Okay.
But everything else, I do love Curtis. I do. But it's just, when you said it would be our little secret.
Okay. I know you told me you often stay with your aunt. Are there things you like about your aunt? Tell me those.
I like when she like, surprised me.
Okay.
I like surprises.
Okay. Are there things you do not like about your aunt?
No,
Gotcha. Gotcha.
I have my to the bottom of my heart.
Okay. Okay. So I have a photograph, and you could let me know if you know this person.
Okay.
Do you happen to know that person?
Oh, sorry, go on.
Do you happen to know that person?
It's not funny, but
Well, I wasn't
I do.
personally, you happen to know this person. Who is that?
my uncle.
That's your uncle? Okay. So do me a favor, can you put your name at the bottom of that paper for me? Just like right here, you can use a marker and just write your name.
Yep, I know.
Okay.
But I didn't know.
Well, you can just write your name at the bottom for me.
With a marker?
Yeah, with the,
Can I put my signature or no?
I prefer your name, so you just make sure you can read the handwriting.
Can I do a pen?
Sure.
Yeah, I know.
Okay. Okay. Thank you.
Miss Chastity. The one thing that made me laugh, like his haircut, 'cause I didn't know if he was, I don't know. That's one thing that made me laugh, but the other things made me cry. And he deserved that photograph. He deserved.
Deserve, emotion, deserve.
I don't know how to say this. He deserves to be locked up.
Okay. Okay, I understand.
Not for years, but he deserves to be locked up.
Okay. Okay. So I know in the beginning, I know you say you felt like it was court and, you want to make sure you were telling the truth and all but the truth. Did I get that part right?
I know I'm telling the truth.
Okay. Did anybody tell you like what to say and what not to say when you come here today?
No.
Okay. Okay. Well, I don't have any other questions for you. Do you have any questions for me about this?
Can I see the picture one more time?
That's for what reason?
Never mind.
You mean, you can see the photo, I don't know, like, how come you want to see the photo?
Chris was wow in that picture.
But is it Curtis?
Yes,
Okay,
I know the state.
okay, okay. But yeah, do you have any questions for me about today or about this? Okay. So if you ever feel unsafe, Randy, or feel like a harm is done to you, do you have anybody that's going to talk to? Tell me who that is.
What do you mean like harm?
Or if you ever feel unsafe or you feel scared, do you have an adult that you can talk to?
Like my worries?
You don't have to be worried. It can just be if you're scared, if you are frightened. Do you have anybody that's an adult that you can talk to?
My family members.
Okay. And who are they? What's their name?
Like if I feel like harm.
It don't have to be harm. It's just feeling you feel scared or unsafe. It don't have to be harm.
My family members.
Okay, and what's their name?
All of them.
No, it's somebody who you can name as an adult.
Like harm. Like what do you mean like harm?
Okay, so if you ever feel scared, okay, do you have anybody that's an adult that you can talk to?
My aunt, my sister.
Okay. Okay. All right. And so what are you planning on doing when you leave here today? When you leave here today, do you have anything you want to do or plan to do?
Go to the park.
Go to the park. Gotcha. All right. I know we had spoke about Curtis Higginsbottom. Is that right? Has anybody else touched you where they're not supposed to?
No, just him.
Okay, all right. Do you want to go back out front to your auntie's ready?
My sister.
Yes, I'm sorry, your sister's ready?
Yeah.
Okay, let's go. And I keep the photo.
Are we talking to the detective today or no?
Well, the detective, he would observe this whole conversation between you and I. Like those cameras, remember those cameras? So he watched the whole conversation. So if you still want to talk to him, you can. All right? Okay.
Yeah, we can real quick.
I'm gonna have him with your sister really quickly, but then you definitely will meet with him. All right? Okay, let's go back up front. And I can keep your photo to my okay. I'll keep the picture that you drew.
I heard those stars.
It's okay.
I heard those stars.
All right.
Your Honor, I'm hearing witness what's been marked as State's Exhibit 23 and 26. What are State's Exhibits 23 and 26?
So 23 is the forensic interview sheet. So basically
How do you recognize it?
oh, I'm sorry. How do I recognize
Yes,
it?
how do you recognize that sheet?
Which one? The
23.
23? Okay, so when we are meeting with the family, the forensic interviewers, the family advocate will give this sheet out to the family.
So don't show it to folks. Just, you can leave it flat on the
I'm
desk.
sorry.
That's okay.
I'm so sorry.
Is it a fair and accurate representation of
Yes.
the intake sheet for Serenity?
Yes, I'm sorry.
Your Honor, the state moves to admit State's
My
Exhibit
bad.
23.
Any objection to states 23?
No, yeah.
It's admitted.
And Ms. Charity, who filled out the intake sheet for Serenity?
Our family advocate, Nicole.
Which of her family members was there?
The sister.
Her sister?
Yes, yes, sir.
And is there anything that would help? Well, do you remember her sister's name?
Yes, Antoinette Mathis. Or Antoinette Mathis. I'm not too sure how to pronounce her first name. I apologize.
And what is State's Exhibit 26?
This was the stars that was completed during a break.
And
Going.
is it a fair and accurate representation of the stars Serenity drew in that forensic interview?
Yes.
Your Honor, the state moves to admit State's Exhibit 26.
Any objection to states 26?
No, you're not.
Admitted.
My bad.
No further questions, Your Honor.
Ms. Feely, do you have questions for Ms. Alocha?
Thank you.
Hey, good morning.
You talked some about your training and experience. I want to go into a little bit more detail with you.
Okay.
You have a master's degree
I do.
and you did the child first training.
I did.
Can you tell us about what that is?
So child first training is a protocol for those that want to be forensic interviewers, also those that are in law enforcement. We also had those that are in, those are the attorneys. So with child first training, it is a protocol that help those that, how can I put it? Just sound like somebody I know. But so child first training is a protocol that helps forensic interviewers actually conduct forensic interviews. That's the most kind of basically I can put it. And it is a 40-week, it's a 40-hour 5-day training. And so with that protocol, you will learn how to basically assess a child for the maltreatment that they're coming in allegedly, and that maltreatment can be child abuse, which is basically more or less basically what we come, the interviews for. But that's not only the case. With Georgia Center for Child Advocacy, we have seen kids come in that have observed domestic violence. We have seen kids come in that have observed murders. We have seen come in that have possibly seen overdosing and their parent had died in front of them. We've seen come in. I've actually interviewed a child that shot himself. So there's not just one particular maltreatment overall. It's a big umbrella, but child first training helps a professional become trained to assess for an interview.
So it sounds like all of this is kind of geared towards preserving the integrity of the interviews that you're conducting, right?
Oh, absolutely.
So you want the conditions most conducive to getting an untainted statement from the child.
Absolutely.
And that means you know how to build rapport.
Absolutely. You know how to build rapport. You know how to transition to a topic of concern. You know how to explore the details. And so when exploring details, you want to obtain the contextual details, the who, the what, the when, the where, sensory details. And I don't want to, if I can go back to Serenity's forensic interview.
Well, I'm sorry,
Oh,
I don't want to
okay.
get you off.
Okay.
I wanted to ask you some more about just your method of questioning.
Yeah.
So you want to avoid suggesting things, right?
Exactly. You want to avoid the leading, but you definitely want to have like the cue recall. Like I mentioned in Serenity's, I will repeat what she said, but then I will also explore more of what she said. I will repeat, for instance, you say you say you had an edible arrangement. Okay, well, what was in that edible arrangement? So you want to explore what that child has said, and that's all in the exploring the details. And then after that, you kind of have gained all the details that you possibly could have gotten, and then you want to kind of go ahead and kind of close off that interview, but you want to do it in a child-friendly way, like I did it with her. And though sometimes you can mess up, but you do want to make sure it's a child-friendly way, because you don't want to never end an interview where the child is kind of thinking about the interview. You want to kind of end up, what do you plan on doing today? You're going to eat some ice cream, going to get some pizza or go to the park. So you definitely want to end the interview in a very neutral, child-friendly way. But overall, the interview is going to be, it should be very neutral, and it should have the child leading the interview. The forensic interviews, though we conduct it, we're never leading the interview. The child is leading the interview. If a child does not want to answer questions, then it does just answer the questions.
And you pointed out that I didn't hear you asking any leading questions in the interview. So you were repeating what she said, but you weren't offering more information to what she's already said, right?
Correct.
So you wouldn't say, for instance, he knocked on the door, didn't he? Right? If she hadn't
Correct.
already said that?
Yeah, you wouldn't want to say he knocked on the door, didn't he? And then the child like, sure, then that'd be suggestive and leading. Yeah,
You know, almost coaching, right?
exactly. Unless you're trying to clarify, if the child said he knocked on the door, and then you repeated it, and then you said, oh, he knocked on the door, and then the child said yes, like, oh, okay, thank you. And then you can go into expound upon those details.
I appreciate that distinction. And I think you already touched on this, but you don't want outside influences when you're conducting a forensic interview, right?
What you mean by that, so I can understand?
So it was just you and her in the room, right?
Yes.
You wouldn't want a parent or other family member in the room.
Absolutely no, you do not want that. And that's what led in towards the end of the interview when I asked anybody tell you what to say or what not to say. That's what we typically ask towards the end of the interview, because you definitely want to know if anybody had told you what to say during the interview, either before you got there or anything like that.
And you didn't have the detective in the room, right?
Correct.
For the same sort of reasons.
Correct.
And it's best practices to have the forensic interview as close in time to the disclosure. Is that right?
Correct. If we can get it scheduled, yeah, that's why it's best to have a good relationship between law enforcement and the CAC at the Child Advocacy Center.
You're not in charge of scheduling though, right?
No, ma'am.
And in this case, you're aware that the disclosure was September 1st of last year, right? It's okay if you're not. But,
Yeah.
okay. But you do know that the interview that you conducted was September 19th of 2022.
Okay. So it's like 19 days apart from, okay. Yeah. Okay.
And during that time, you don't have any idea who she might have spoken with?
No, from what she said in the interview is that she spoke to somebody at the school. Yeah. So we'll take time for the school to notify somebody, and then the parent, which is I guess the caregiver at that time, to make contact with law enforcement, and then law enforcement to make contact with the CAC, which would be the Georgia Center for Child Advocacy, and then we would get scheduled. So yeah, 19 days is, not that bad, but understandably, a lot of children do suffer from child abuse and sexual abuse.
Good. And your interview, I think total was about 53 minutes, including the break that was taken.
Okay.
So that's pretty standard for a child her age, would you say?
I would think so.
And if an untrained person interviewed her for an hour to 2 hours, an hour and a half to 2 hours, that would not really be appropriate, right?
I cannot say I don't know. Because it depends on what questions they're asking that child, and will that child be comfortable disclosing, and what they have built their rapport, so I can't really answer that.
That's fair. But a layperson should not be interviewing a child about sexual abuse.
No.
That's all I have at this time around.
Okay. Any redirect?
Briefly, Your Honor. Ms. Charity, when you work at the Georgia Center for Child Advocacy, have you ever had a child just walk in off the street and you're the first person they've ever spoken with about the abuse?
Can you ask that one?
Have you ever had a child walk in off the street and you're the very first person they've ever spoken with about the abuse?
No.
Do typically, when you get a child for an interview, do you have a little bit of background information about what they're coming to discuss?
We have some minor.
And in general, where does that typically come from?
Law enforcement or DFACS.
No further questions, Your Honor.
All right, Ms. Feely, anything else?
No, Your Honor.
Questions from the jurors? Yes, all right, if you'll pass them down towards Deputy Gordon, please. Thank you. Counsel?
Oh, it was a good dinner too. I took my medication. Oh, it felt so good. Felt so relieved. Oh, you wouldn't.
Ms. Alocha, you used the term assess, that part of what you're doing is you're assessing the child. Can you tell the jurors what's meant by that term? Obviously, it's not like a physical examination. You didn't take her temperature or hit with that little rubber hammer.
I got you.
So what do you mean in your role as the forensic interviewer? What does assess mean?
Okay, so when you are assessing, right? Assessing in social work terms. Okay, no, I'm sorry. So assessing is not only are you interviewing that child and you are gathering information pertaining to the alleged maltreatment, whether that is sexual abuse, physical abuse, domestic violence, whatever that child is there for, you're assessing, you're obtaining information. Like when you go to the doctor, that doctor is assessing, he's determining, do you have high blood pressure? Do you have obesity? Do you have whatever information, what you're there for, right? You're assessing. But not only are we there to gather information about why that child is there for the alleged maltreatment, we also have to make sure that child is still safe in the home with that caregiver, correct? Because we're still social workers. We're still there to make sure that child is safe. So that's what I mean by assessing. But it can be in terms of interviewing. It's interchangeable. Does that make sense?
So yeah, you don't get to ask them questions. It either makes sense or doesn't make sense, but you answered the question. So thank you.
Okay, you're welcome.
Next, as part of your evaluation or assessment and interaction with the interviewee, the person you're talking to, do you ever look at body language or speech patterns? Is that ever a key or a cue to anything? Does that make sense?
P and Q to anything in regards of what?
When you're assessing the situation, if, I'm just as an example, a child never raises his head from the table, speaks to you only with his head down, never makes eye contact.
Okay.
So that would be a physical manifestation of something, that's body language, or you just crossed your arms. When a child is talking about something, she crosses her arms, but in another topic, she's not crossing her arms.
It's a child's effect. Uh-huh.
Okay, so we'll say effect.
Uh-huh.
Is that something you are looking at and assessing the child's effect while you're interacting with the child?
Absolutely.
Okay. Were there any effects that you noticed with Serenity Mathis? Not what they signified, but things you noticed that were noteworthy to you.
Absolutely.
What's an example of an effect you noticed?
She was highly emotional. She was crying majority of the interview.
Okay. Mr. Atkins, do you have any follow-up for Ms. Alocha?
No, Your Honor.
Ms. Feely? All right, we appreciate your time. Thank you so
All right,
much.
Thank you so much.
So my recollection from our discussion yesterday is that your next witness might be a half hour or more.
Yes, Your Honor.
Okay, we'll take our morning break then. I think the state has just one more witness. We'll see. And we'll hear from that witness when you all come back. Enjoy the jury room, the hallway, et cetera. And we'll try to get you back in here in about 10 minutes. Don't talk about the case. No outside research. Thank you. Mr. Jordan, anything from the state before we break?
No, Your Honor.
Your remaining witness is here.
Yes, Your Honor.
All right, Ms. Feely, anything before we break? All right, we'll see everyone in about 8 minutes or so. Thank you.
Actually, Your Honor, I do apologize. I've told Ms. Feely this already, but the state does intend on playing what's already been admitted, Exhibit 16, a very, very small portion of the reporting officer's body cam.
Through this next witness?
Yes, Your Honor.
I mean, it's in evidence, so you can play it.
Yes, Your Honor. I just want to make Your Honor aware of
Okay, thanks for sharing.
that. Thank you.
All right, see you guys shortly.
Every device as well.
What does that mean?
On real time, it's like, so it's taking my time.
Oh, because it's going, grabbing in this and this.
All this happens.
Really? They said there's some network issue, not just in here, but in several places, and they'll try to fix it for next week's trial, but it will take a while, and he needs to get on a computer or do something. Huh. So they're not on. Oh, yeah, it's gone. No, it was. I saw it. It popped up. Interesting. I'll try to add it. Yeah, it's your Bluetooth.
My Bluetooth is connecting to all the TVs, everything.
Yeah, it's not liking that. Don't know.
Like a ghost is in here.
Yeah, that's funny. I think it's hard. Tell me that. Yeah. He said, just
I've got you on there 1,000 times. It's okay. It's all right.
what did you say? I just wanted to. It's fine. Text me out. Child advocacy center questions again, someone else to go over, but I'll make sure not to like re-say what chair you're on, because I think she did a fine job.
Ms. Rivers, are you ready? Great. Let's go back on the record in State versus Higginsbottom. Mr. Higginsbottom is here in court with his lawyer, with our prosecutors here. Mr. Jordan, are you ready for the jurors to come back in?
Yes, Your Honor.
Ms. Feely?
Yes, sir.
Let's bring them in, please.
All right, jurors.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. We are ready for the state's next witness, who is
The state calls Miss Mindy Paylor.
You swear affirm that the testimony you give is the truth, the whole truth, and nothing but the truth, so help you God. You know you have seen. Can you say this in the record?
Mindy Paylor, Mindy, P as in Paul, Aylor.
Good morning, Miss Paylor. How are you?
I'm good. How are you?
Can you tell the jury where you're currently employed?
At the Georgia Center for Child Advocacy.
And do you have any experience in working with children?
Yes.
And what is that experience?
At the Georgia Center for Child Advocacy, it's an advocacy center where we provide services for children.
Okay. And does that center work with law enforcement as a part of criminal investigations?
Yes.
And how long have you been employed there?
10 years.
And what is your current role or title?
The Assistant Director for our Forensic Department.
And what are your duties and responsibilities as a part of that role?
I maintain the day-to-day operations. I conduct forensic interviews, train new staff members, and things like that.
And what is your educational background?
An associate's degree in early childhood education and a bachelor's in sociology.
Do you have any specialized training in interviewing children?
Yes, Child First.
And what is Child First?
Child First is a 40-hour intensive course where they focus on interviewing children, child development, and child abuse.
And how many forensic interviews would you say that you have personally conducted yourself?
A little less than 700.
And have you observed other forensic interviews?
Yes.
And do you participate in peer review?
Yes.
And can you explain peer review to the jury?
Peer review is basically where the Atlanta area interviewers all come together and we review each other's interviews and provide feedback.
Your Honor, at this time, the state will move to tender this witness, Ms. Mindy Paylor, as an expert in the field of forensic interviewing and child abuse, including the process and technique of forensic interviewing, disclosures of sexual abuse, including delayed disclosures of sexual abuse, issues of memory, recalling, coaching, and recantation.
So you covered about 1/15 of that list, forensic interviewing. Now, those all may be aspects of it. If you want Ms. Paylor declared an expert in all those subsets, you're going to need to ask her a whole bunch of questions about those subsets. If you want her qualified as an expert, and I'll consult with the defense in just a moment to get their input, as an expert in the field of child forensic interviewing, I'm prepared to rule on that.
Yes, Your Honor, I'll proceed forward with the questioning if the defense has any objections to her being administered as an expert in all of those fields, but I'll defer to Ms. Feely.
Okay, so Ms. Feely, what are your thoughts? I can't even repeat that roster of things for which Ms. Paylor was being tendered as an expert. And I appreciate there are aspects of child forensic interviewing, but when we qualify a medical examiner as an expert, we don't say, and she knows a whole lot about kidneys and the spleen and things like that. So tell me how you'd like to move forward. From what I've heard, just to forecast, I think Ms. Paylor is eminently qualifiable as an expert in the field of child forensic interviewing, of which there may be many subsidiary topics that she could discuss. But I'm interested in your perspective.
No objection to her being qualified as an expert in the field of forensic interviewing.
Okay. That's what I'm going to do for now. If you need to have Ms. Paylor qualified for certain subsets of that as well, you can. But I think having qualifying her as an expert in the field of child forensic interviewing will allow you to explore those topics. If we start getting objections as to not qualified to offer an opinion on that, then we can drill down on those.
Yes, sir.
Okay, so Ms. Paylor, I am qualifying you as an expert in the field of child forensic interviewing for purposes of your testimony at this trial.
So Ms. Paylor, what is a forensic interview?
Forensic interview is a neutral conversation between a forensic interviewer and a child where the purpose is to gather detailed information about something the child either experienced or witnessed.
Okay. And typically, why would a child be referred to the Georgia Center for Children's Advocacy to undergo a forensic interview?
They either experienced or witnessed abuse, and there's an ongoing criminal investigation.
Okay, and is there a particular protocol or procedure you follow to conduct a forensic interview?
Yes, Child First has a protocol.
And what is that protocol?
We go with the RTEC protocol. We start with rapport building. You want me to go through the stage?
Yes, please.
Okay. We start with rapport building, and then we transition to topic of concern. Then we explore details, then we close the interview. And during the rapport building stage, that's where the interviewer talks to the child, gets them comfortable with the room. They do narrative practice, which helps them understand how a child will cause an event. And then after that, they'll transition to the topic of concern, which is where a child may just make a disclosure. And if a child makes a disclosure, they explore the details of that disclosure. And then after that, we go on to closing the interview. We might talk about family, friends, just so that what the child does talk about isn't the last thing they're thinking about when they leave.
And where are forensic interviews conducted?
At child advocacy centers.
And who is in the room when these interviews are conducted?
Just the child and the forensic interviewer.
Okay, and do you normally meet with caregivers before or after the interview?
We meet with them briefly just to introduce ourselves, but we don't have long conversations.
And generally, what information do you have prior to these interviews?
Demographics and maybe a line or two about the allegations and what's being investigated.
And earlier you stated something about rapport building stage. Can you elaborate upon that for the jury, please?
That's basically where we let the children know about the cameras that are in the room. There's a detective or a DFACS watching from a different room. We do narrative practice. We might talk about an event that they just had, maybe sports or a birthday or anything, just to, again, understand how they recall an event.
And what about the topic of concern stage?
That's where the child may make a disclosure, and we ask them what they're there for, and they may make the disclosure.
And do you normally explore details during these forensic interviews?
Yes.
And what kind of questions are normally asked during the forensic interviews?
We ask open-ended questions.
And why open-ended questions?
Because it's important for the child to be able to give us a narrative, and so we can get information from them.
And do you provide any instructions to the child as part of your protocol?
Yes,
And why do you do that?
just so that they understand that they can correct us if they're wrong. A lot of times children see adults and they think, oh, I can't correct them, or I can't tell them they got something wrong. So it's important that they understand that they're leading the interview. And if we say something wrong, for them to let us know, or if they don't remember something, they don't have to guess to give us an answer.
Okay. And do you use anatomical drawings or dolls in the interviews?
Yes, when necessary.
And why?
For clarification.
And is there a normal time in the interview that you normally do that?
After a child has made a disclosure.
Does an interview vary depending on a child's age or developmental level?
The protocol is the same, but you might structure it different because you might speak differently to a teenager than you would to a preschooler. So the language might be different.
And can you give the jury an example of how you would talk to a teenager as opposed to talking to a preschooler?
For example, I might ask a teenager, I might say, tell me about yourself, but to a preschooler, I might ask them to tell me what they like to do. So it's a little more direct.
Will you also, as a forensic interviewer, look for developmental cues?
Yes.
Do you curtail the questions that you ask based upon the age of the child that's being interviewed?
Yes.
Can you describe to the jury what suggestibility is when referring to the forensic interview of a child?
Suggestibility is basically when a child gives a response that's influenced by something outside of the actual occurrence.
And what age of children are generally the most susceptible to suggestibility? 5
and under.
And are there any other factors that impact whether a child is more susceptible to suggestibility?
Coaching.
And can you define coaching for the jury?
Coaching is when someone tells a child what to say during a forensic interview or to anyone that's talking to them about the investigation.
Okay. And in the interview, do you do a test for coaching or look for coaching?
We look for coaching, yes.
And how are you able to tell if a child has been coached or not?
Lack of contextual details, and if they're not able to elaborate on their statements.
Now, can you tell the jury, earlier you said that at a certain stage that there's a disclosure that's made. Can you define the word disclosure for the jury, please?
That's when a child makes a statement that they've been abused.
And what is the process of disclosure?
The process of disclosure is basically how a child talks about what's happened to them. There's 5 stages. Start with denial, tentative, then active, reaffirming, and recanting and then reaffirming. And depending on which stage the child is in is how they will talk about what happened to them.
And are there different types of disclosures?
Yes.
And what are they?
There's either.
Objection, Your Honor, I think this is outside the scope of what this witness has been qualified for at this point.
Okay, we may be getting into this area where you need to qualify in a different dimension. Can you ask the question again?
The question was, what are the different types of disclosures?
Okay. And Ms. Feely, well, what do you mean by that? As in, you might disclose that there was physical harm or psychological harm, or?
I believe, Your Honor, the previous question was, are there different types of disclosures? And I apologize if that's incorrect. And I was using a follow-up question to ask, what are the different types of disclosures?
Right. No, I understand what your question was. Do you expect the answer to be something like there's a modest disclosure, or it's hard to know if she's qualified because I don't know if the answer is one that's highly technical. I suspect you know the answer since you're asking it.
And Your Honor, I believe that this goes to the primary purpose of, as Ms. Paylor has been introduced, that she's conducted over 700 forensic interviews. She's received training. And
so let me tell you my concern. If what you're expecting is that Ms. Paylor will say, they're good disclosures that we really believe, they're bad ones that we don't believe, that's a problem and you can't go there. But you're not telling me what you expect the nature of or is it a numerical system? We have disclosures that we call number one, where there's lots of detail, and disclosures that we call number two, where it's real vague, and then we know we're going to need to see if there's additional detail we can get. I can't evaluate the motion unless you can give me a little bit more as to what you expect. I don't mean word for word, you're not the witness, but where is this going?
This would more or less go to the timing of the disclosures, Your Honor.
A delayed disclosure.
Yes, Your Honor.
Okay, all right. If that's what you're talking about, then the objection is overruled
Thank you.
at this point.
What is a delayed disclosure?
Delayed disclosure is when a child does not take the opportunity to discuss what happened to them and they wait a little bit before they tell somebody.
And is there also what is an immediate disclosure?
Immediately after something happens, they tell someone.
And are there any other, are there any kinds of disclosures that, I'll rephrase, what is a purposeful disclosure?
That's when a child makes the statement themselves.
And what is an accidental disclosure?
That's if somebody else may witness it or come across something they see themselves.
And could the type of disclosure affect how a child engages during a forensic interview?
Yes.
How so?
If it's purposeful, they tend to be ready to talk about it. If it's accidental, sometimes they can be reluctant.
Are delayed disclosures typical?
Yes.
What factors might impact a delayed disclosure?
A number of factors: the child's age, child sex, maybe their relationship to the abuser.
And can you elaborate upon the relationship to the abuser and how that affects disclosure?
Sometimes the child may know their abuser and they may love their abuser, so they don't want the abuser to get in trouble.
And could the abuser being a family member affect the disclosure?
Yes.
Now, in your experience, Ms. Paylor, do children sometimes attempt to downplay or minimize the extent of the abuse or its impact on them?
Yes.
How so?
Just like you said, they downplay it because some children don't want to be seen like victims, so they act like what happened isn't that serious to them. Or again, because of the relationship, they don't want someone to get in trouble, so they might minimize the facts or leave things out.
Now, Ms. Paylor, assuming that you yourself are interviewing a child that discloses sexual abuse, what kind of information are you looking for as a forensic interviewer?
During the interview, look for contextual details. And like we talked about earlier, check for coaching and suggestibility.
Now, you've mentioned contextual details, and you may have elaborated upon this earlier, but can you tell the jury what type of contextual details you would be looking for?
Contextual details such as the who, what, where, maybe what they were wearing, what they were doing, things like that. Detailed information.
Now, in your experience conducting forensic interviews, are children always specific about exactly when incidents occurred in terms of dates and times?
No.
And how might a child describe generally when an incident of sexual abuse occurred?
We tend to go by age or maybe what school or what grade they were in, or if it was a holiday, something like that.
And in disclosing sexual abuse, are children typically able to remember every single detail in the complete order of chronological events and what happened to them?
No.
And why not?
A lot of times, if it's something that happened more than one time, it's hard for them to tell you what happened at which time.
And in your experience, can the frequency of abuse affect what a child remembers?
Yes.
How so?
They wouldn't be able to differentiate what happened maybe the first time versus the third time, and they kind of intertwine all the times.
How would a single instance of abuse differ from multiple times of abuse?
You get more detail with the single and get more of a chronological order of how the event took place.
Can you tell the jury what multi-episodic abuse is?
That's when something has happened to the child more than one time.
And what is script memory?
Script memory is how a child recalls something, and when they're telling you, they give it to you kind of like a script.
Now, what's the difference between a forensic interview and My apologies. What is different between a forensic interview and live testimony in a courtroom?
Forensic interview is just the child and the interviewer. Law enforcement's not even in the room, so it's less people. And live in a courtroom can be intimidating or scary.
Now, are there any factors that might account for inconsistencies between a child's statement in a forensic interview and their testimony in a courtroom?
Objection, Your Honor. Same. I think this is outside the scope of what she's been qualified for.
Can you repeat the question, please?
Yes, I asked, are there any factors that might account for inconsistencies between a child's statement in a forensic interview and her testimony in a courtroom, or their testimony in a courtroom?
How does that fall within someone who's been qualified as an expert about forensic interviewing as opposed to the dynamics of in-court testimony?
Specifically, Your Honor, there has already been testimony about the environment that a forensic interview is conducted in, which is made to make the child more safe and comfortable. And I believe Ms. Paylor's last answer to how live testimony in a courtroom is different. There's multiple people in there. I believe that she can sufficiently answer this question as opposed to the safe environment where the children are.
Okay, I'll stop you. You're making a good closing argument, which I think you're free to do, or Mr. Adkins, but I'll ask you to move on to the next question.
Understood, Your Honor. Can time affect a child's disclosure?
Yes.
How so?
The more time that goes by, they might forget certain details and basically they might forget certain details.
Now, did you have the opportunity to review a forensic interview by the child of the name of Serenity Mathis?
Yes.
And what were your overall thoughts of the interview?
I thought it was a good interview. We don't have any perfect interviews. There's always some things that are, that's why we have peer review, because there's always feedback to give on interviews. But there were a few things that I may have done differently.
And what were the things that you may have done differently?
Part of the interview while I was watching it, Serenity stated that she was concerned about her aunt being in trouble or asked about her aunt being in trouble. I would have explored that. There's some additional things that I may have explored. And then also, I believe the forensic interviewer introduced the word penis during the forensic interview. I would always let the child be the one to introduce body parts.
And do you know the forensic interviewer that was in the video interviewing Ms. Mathis?
Yes.
And how do you know her?
She worked at the Georgia Center.
Now, did you yourself train her?
Yes.
Now, what part of the interview between Charity and Serenity was the rapport building section?
That would have been in the beginning when they were talking about, I believe it was a skating party for her birthday.
And how did Charity engage Serenity?
Just asked the questions about her birthday.
Now, did Charity give Serenity an opportunity to correct her during the narrative practice?
Yes.
And what is the narrative practice?
The narrative practice is at the rapport building stage where they were talking about the skating.
And what were your observations of Serenity's demeanor during the narrative practice?
She was excited to talk about her birthday.
And what was your assessment of her developmental abilities?
She seemed to have a delay, given her age, the responses that she was giving, they didn't seem age appropriate.
How did Charity move to the topic of concern?
I believe she asked her if she knew what she was there for that day.
And as part of your observations, did Serenity's demeanor change during the topic of concern?
Yes, she was less excited. She cried during both the narrative practice and during the topic of concern, but during the narrative practice, she said it was tears of joy. She was talking about going to high school or junior high. And then during the transition, she was less excited to talk about that.
And what type of disclosure did Serenity make?
A delayed disclosure.
Now, as part of your observation, when Charity moved through the topic of concern, did you believe that Serenity was comfortable discussing the abuse?
She looked like she was okay discussing it, but it looked like something that she knows herself that she wanted to do, because she even expressed that she wanted to get it off her chest.
Now, does a forensic interviewer give the child an opportunity to embellish?
Yes.
And what is embellishing?
That's when a child may make additional statements that may not, make additional statements to questions that are asked.
And did Charity do that for Serenity in this interview?
Yes.
What contextual details did you observe in Serenity's interview?
She talked about who did something to her. She talked about what they did, location. She talked about conversations with her aunt. She talked about things that were said to her during the abuse.
Did you see any signs of suggestibility in the interview?
No, Serenity corrected Charity a few times. And if she was confused about a question, she asked her, "What do you mean?" several times throughout the interview.
And was her disclosure consistent with any coaching?
No.
Now, can you explain to the jury what grooming is?
Grooming is when an abuser manipulates a child basically and builds a relationship with them.
And as part of your observations in watching this video, what was the dynamic between Serenity and her abuser?
Her uncle, she called him her uncle.
Did you see any evidence of grooming between Serenity and her uncle?
Just the relationship. She talked about them having a good relationship.
Did you see any details of manipulation?
Yes. She said he told her not to tell her aunt or she'll get in trouble. She said that he said it was their secret. And he also said that she's not a baby anymore, things like that.
And can you tell the jury what a non-supporting caregiver is?
Basically, if a child discloses to their caregiver and their caregiver may not believe them or support them in their disclosure.
And how can a non-supporting caregiver affect a disclosure?
Children recant a lot of times when their caregiver doesn't support them, or they might give limited details or change some of the details.
Now, based on your experience, Ms. Paylor, was Serenity's disclosure consistent with the child who has experienced sexual abuse?
Yes.
As part of your watching the video, do you recall if Serenity talked about why her disclosure was delayed?
Yeah, she said she just couldn't tell her aunt. She didn't know how to tell her.
If I may have one brief second. Now, earlier, Ms. Paylor, you did have some critiques of Charity's interview. What was your overall assessment of the interview?
I think even given the critiques that I did have, because Serenity was able to correct her and make sure she clarified questions, I think it was a good interview.
Now, is body language of a child also a part of assessing that child?
Yes.
And how can that affect the assessment?
Sometimes children talk the whole time their heads down. Sometimes their legs are shaking. Sometimes they're sitting up when they're during the rapport building stage, and then they kind of slouch a little bit once you start transition topic of concern.
And what were your observations of Serenity's body language?
She seemed pretty consistent throughout the interview.
And by pretty consistent, what body language was consistent?
She just sat and talked. She didn't shake her leg or anything. She didn't slap us down at any time. She was very emotional though.
No further questions at this time, Your Honor.
Ms. Feely, questions for Ms. Paylor?
Thank you, Anna. Good morning, Ms. Paylor.
Good morning.
You talked about your training and experience a little bit.
Yes.
you did the Child First Georgia training to be a forensic interviewer, right?
Yes,
And then you did the Child First Expanded about the forensic interview process.
yes,
And you have conducted almost 700 interviews.
yes,
And you've watched more than that.
yes,
And you completed the Beyond the Basics Advanced Peer Review
yes,
and self-review strategies for forensic interviewers.
yes,
And you participate in metro area and in-house peer review.
yes,
So fair to say you know how to build rapport
yes,
and conduct the narrative build practice section,
yes.
and you know how to avoid coaching,
Avoid coaching or
avoid
assess-
suggestibility or
Yes.
suggestion. Okay. And all of this training experience is geared towards preserving the integrity of the interview.
yes,
And you want the conditions to be most conducive to get an untainted statement from the child.
yes,
No outside influences.
right,
And you know it's important to have the forensic interview as close in time as you can to the disclosure.
yes,
And you don't have anyone else in the room,
no,
no parents,
no,
no law enforcement,
no,
because their presence could affect what the child is comfortable talking about.
yes,
Here, the disclosure was September 1st of last year. Are you aware of that?
no,
It's okay if not. So the forensic interview was actually September 19th of 2022. So 19 days between the two. That's not best practices, right?
I wouldn't say not best practices, because typically when we do interviews, a lot of times they are delayed disclosures.
And are you aware that she gave statements to multiple other people?
No,
So it's your professional opinion that it is not good for lay people to be interrogating the child about accusations, right?
correct.
And why is that?
Just because the environment could be different, they may ask questions differently.
So if an untrained person questioned Serenity for an hour and a half to 2 hours, that would not be something that you would have recommended. Is that
No.
fair? Thank you. Because that is inappropriate.
Right.
And the forensic interview itself actually was much shorter than that.
I can't remember how long the forensic interview was, but I think it was like an hour, I believe.
Now, you also used to work briefly for, was it the DeKalb DA's office?
Yes,
And whose job it is to prosecute cases just like these, right?
correct.
You work closely with prosecutors
Yes,
and the police.
yes,
You testified that Serenity's allegations and the way she made them was consistent with abuse. Is that right?
yes,
And you're aware that she told the school social worker the next day.
yes,
And so that would be a delayed disclosure.
correct.
But if she had run to her aunt's room right after this happened, that would also be consistent with abuse, right?
Yes,
And if she had called her sister as soon as it happened, that would be consistent with abuse.
yes,
If she waited 3 weeks and told somebody then, that would still be consistent.
right.
If she waited a year or 3 years, you would still say that's consistent with abuse.
Correct,
And like you mentioned, sometimes there could be no outcry.
correct.
Some other evidence brings the case forward, whether it's injury or pregnancy or something like that.
Correct.
And then the child talks
Discloses.
about it. And that's, of course, consistent with abuse.
Yes,
So the outcry could be immediate, delayed, or none at all, and all of that is consistent with abuse.
yes,
You talked a little bit about recanting. Recanting can be part of the disclosure process,
yes.
but not recanting is also can be normal.
That can be normal.
And it's also not uncommon for there to be minimizing, right?
Right,
And that would be consistent with an allegation of abuse.
correct.
But not minimizing and always sticking to one story is also consistent with abuse.
Correct.
And you talked about grooming sometimes, in some cases, there is evidence of grooming, right?
Right.
And that's consistent with abuse.
Yes.
But other times, there's no evidence of any grooming, right?
Correct.
But that would still be consistent with abuse.
Correct.
And examples of grooming would be like offering the child money, for instance,
That can be grooming.
or offering screen time privileges.
Yes.
Or gifts.
Yes.
And often the abuse will start gradually and increase.
Yes.
And you talked about contextual details, the where, the what, the all of like what they were watching or wearing, things like that.
Right.
And often a child will be able to recall contextual details, right?
Yes.
And that is consistent with abuse.
Yes.
But sometimes they just don't remember any contextual details, right?
Right.
And that you would say is also consistent with abuse.
That's when the unlikely comes into place, that something may not have happened because of the contextual details.
And sometimes those contextual details can be corroborated,
Yes.
like the curtain was brown or the gray bedspread or something like that.
Yes.
And you think you testified that you're trained to look for evidence of coaching.
Yes.
And to be clear, when we're talking about coaching, we're not necessarily only talking about somebody telling the child what to say, right?
Right.
So it could also just be an adult inadvertently kind of leading a child.
Suggestibility.
It can be just by untrained adults unintentionally questioning the child in a way that suggests.
Yes, that would be
details.
more suggesting than coaching.
And making them repeat the story.
I don't understand the question.
So having the child repeat the story numerous times could affect what they're saying.
Affect to what? Affect how?
Affect, let me jump up because you mentioned suggestibility. Let me jump to that.
Okay.
So suggestibility means the child's answers are influenced by something other than what actually happened.
Right.
So things that could affect suggestibility are, like you already talked about, the way the question is asked.
Yes.
So an example, you wouldn't ask in a forensic interview, he touched your butt, didn't he?
No, I would not.
And you mentioned here, the forensic interviewer, Serenity never used the term penis until the forensic interviewer said it, right?
She never said penis. She said private part after the interviewer said penis, but the interviewer introduced penis.
And like you said, there's no perfect interview.
No.
But that was something you would have done differently.
I would have done differently.
Because in the risk of asking a question that suggests an answer is a suggestible child might say, yes, I was touched there. Right?
Yes. In this case, Serenity was older, and suggestibility is normally when children are 5 and younger. And she was able to correct Charity in multiple instances. So the looking for suggestibility or thinking that she was suggested by that, I would have, if I was the one interviewing it, I would not look at that as a big concern because she was able to correct her throughout the interview.
Another thing that can affect suggestibility is learning differences. Is that fair?
Yes.
So like a child who is mildly autistic, you would want to take extra precautions about suggestibility, right?
I wouldn't necessarily take extra precautions, more so like I was talking about how I do the interviews. I might change my language based on how they're understanding the questions that I'm asking, and I might ask more direct questions.
And when the child is answering your questions, it's fair to say you don't react one way or the other. You try to stay neutral to what the child's saying, because an untrained adult who asks a question may inadvertently react with approval.
Correct.
Or disapproval.
Correct.
And that could affect what the child is able to talk about.
Yes.
Because if they get a supportive response, they might continue.
Yes.
And you talked a little bit about the child, the affect, I think was the term. So it's, if the child is crying and emotional, that would be consistent with an outcry of abuse, right?
Yes, children react all different ways during forensic interviews.
And if the child was withdrawn or hesitant, that would be consistent.
Yes,
And even if they were laughing, that would be consistent.
yes,
Or angry, not wanting to be there is consistent.
yes.
And you mentioned that Serenity cried during the narrative. Trying to think of the term of art, the narrative practice section.
Mhm.
That, in your opinion, is still consistent with abuse.
I want to be clear when I say it's consistent, when I say her disclosure is consistent, meaning when she was talking about the contextual details, but talking about how children present themselves, all those could be a different range of ways. Children act all different ways and come all different. They act different throughout the interview. So when I say that it's consistent, it's more about what she's giving, the contextual details that she's giving.
That's all I have in terms of questions. Thank you.
Thank you.
Mr. Jordan, any redirect?
Yes, Your Honor. Ms. Paylor, does the fact that a child has spoken with other people before a forensic interview keep that forensic interview from garnering valid information?
No, most of the time the child has spoken to someone before they come to us.
And you spoke earlier about Charity introducing the term penis to Serenity. Does the fact that a forensic interviewer introduces a term, can that taint a forensic interview?
No, well, it can, but not necessarily, depending on how the child responds. And in this case, as stated before, Serenity was able to correct Charity multiple times before she even mentioned the word penis. And I'm confident from watching the interview that she would have corrected her if they weren't talking about the same thing.
And also, as part of your duties, are you aware of how scheduling works at the Georgia Center for Child Advocacy?
Yes.
How does it work?
Scheduling forensic interviews?
Yes.
We get referrals from investigative bodies, whether that's DFACS or law enforcement, and then our intake coordinator schedules the interviews.
Can anyone, a lay person, just call and schedule a forensic interview?
No.
So if I have you correctly, the law enforcement is the only body that can call and schedule a forensic interview.
Law enforcement or DFACS.
Your Honor, if I may have 1 brief second. No further questions, Your Honor.
Okay, any recross?
No.
Questions from the jurors for Ms. Paylor? Seeing none, thank you, ma'am, for your testimony.
Thank you.
Appreciate it. Mr. Jordan, your next witness.
Your Honor, the state rests.
Okay. Ladies and gentlemen, the state has rested, meaning you have received all of the evidence from the state, witness testimony, exhibits, et cetera. And we will, in a bit, turn to Ms. Feely to see if the defense is going to present any evidence. They have no burden of proof. They're not obligated to present anything. But we need to take a quick break as I forecast for you. There are a couple of things I need to work through with the lawyers before I can turn to Ms. Feely to ask her if she's going to call any witnesses. We will get to that phase, i.e. I ask Ms. Feely what she wants to do or what she plans to do before you go to lunch. So this will be a shorter break. I do have to work through a couple of things with the lawyers. We're not breaking, you are. I'll bring you back in, but just to manage your expectations, it could be a little choppy in that I bring you back in and Ms. Feely says, at this point, the defense rests. We'll probably take the lunch break then. If the defense is putting on evidence, we'll go for a little while until a natural break point. But just to manage your expectations, maybe up and down a couple times. If you'll go with Deputy Gordon, the fact that the state has rested doesn't mean you should start deliberating, do any outside research or anything like that. Just enjoy the break room and that hallway. We'll get you here soon.
All right, sir.
All right, you all can be seated. Ms. Feely, any motion now that the state has rested?
Yes, Your Honor, we would move for a directed verdict on count 1.
Okay.
The evidence of that is unsworn statement that the complaining witness gave to the forensic interviewer. There was no testimony under oath about that. And as the court heard, Serenity never said the word penis until after it was suggested to her. So we would ask the court to direct a verdict of acquittal on count 1.
All right. Mr. Adkins, I recall, I think sufficiently for purposes of our discussion, what was discussed in the forensic interview. So you don't need to get into that content. I am intrigued by Ms. Feely's characterization, I think accurate characterization, the impact of it, that there's no sworn testimony from anyone that the allegations in count 1 occurred. There was a video played in which Serenity Mathis does discuss that, but that wasn't her testimony in court. Is it still evidence? And if so, how is it evidence that a jury could rely on?
Yes, Your Honor, it is evidence. State's Exhibit 24, which is the forensic interview, was admitted absent the brief redaction. There is, and I can, if the brief moment, cite ample cases, but oftentimes in children cases, the child does not disclose the abuse that took place. The forensic interview was properly admitted. There is no case or legal rule that the child has to testify about that element at trial, Your Honor. And I know this court is aware, because you just mentioned about the state does put forth that the statement Serenity did give in the admitted portions of State Exhibit 24 do meet the elements from what she says, and also the reasonable inferences that the jurors can use their common sense that, and I'll just briefly, because she mentioned sucking his penis, that would involve her mouth on his penis. And she also had a little bit of descriptive contextual details about something that was on his penis. With that said, Your Honor, the state feels that there is more than enough evidence to survive a directed verdict on count 1, the aggravated child molestation, with the evidence admitted at trial, Your Honor.
Okay. Ms. Feely, anything you want to add? Now that I think about it more, I don't disagree with you that there's been no sworn testimony, which is one form of evidence that something happened. But let's use a different context. A hypothetical. Serenity Mathis testifies exactly as she did in this trial. There's a video of what she disclosed in the forensic interview. She doesn't have a forensic interview. She just testifies, you know what, I don't remember anything happening other than August 31st. But there is a video, because there was a camera in her bedroom, that shows what she alleged happened in the forensic interview. And that's what gets admitted. That's not sworn testimony, but it's still evidence. And so really, doesn't your concern about Serenity Mathis's statements to Ms. Olocha being unsworn go to the weight of that evidence? And of course, you've got the inconsistencies in court. No, there really wasn't anything I remember beyond August 31st, 2022, with what is in the recorded statement.
I think a video of the actual event occurring is different than the hearsay evidence that was admitted through the forensic interview. I mean, obviously under child hearsay, I'm not saying it was admitted improperly, but I think they're just different types of evidence. Her saying it happened to somebody else versus it actually being on video.
Okay. I think they are different in the sense that one is much more powerful than the other. The video of the alleged incident versus someone saying in a recorded interview. But I do think that that is evidence, and it's evidence that the jurors are entitled to consider, and they could sort out the inconsistency between Ms. Serenity Mathis's in-court testimony with her out-of-court statement in a way that is in favor of the state's case, which is how I have to view all these conflicts in the evidence, that the jury, for purposes of your motion, that the jury resolve those conflicts in favor of the state. They may not do that, but as you know, the bar is high to grant a directed verdict, and I need to resolve those conflicts favorably for the state solely for that analysis. And so I find that the Center for Child Advocacy video is part of evidence. Jurors may consider that, weigh it as they will, and that would be enough for reasonable jurors, rational jurors, to find the defendant guilty beyond a reasonable doubt as to count one. So I will deny the motion as to count one. Anything else before I talk with Mr. Higginsbottom about testifying?
No.
Mr. Higginsbottom, I previewed this, I think it was a couple days ago, because I thought we'd have this conversation yesterday. I need to ask you a few questions and share a few things with you about your right to testify and to not testify. Are you ready to have that conversation?
Yes, sir.
Okay. Do you understand, Mr. Higginsbottom, that you have a right to testify, and that if you want to testify, no one can prevent you from doing so? I need you to answer out loud.
Yes, sir.
Okay. In other words, if you want to take the stand, even if Ms. Feely is saying, don't do it, it's your call, not Ms. Feely's.
Yes, sir.
Okay. Do you understand that in the same way, but in the opposite direction, no one can force you to testify? In other words, if you don't wish to testify, Ms. Feely doesn't have a way to get you on the stand magically. The state cannot call you as a witness. You're deciding Mr. Higginsbottom testifies or he doesn't testify, and you have an absolute right to go in either direction. You understand that?
Yes, sir.
Do you understand that in just a few moments, I'll be asking you, and not Ms. Feely or anyone else, if you are choosing to testify? Do you understand that if you choose not to testify, to remain silent, I will be instructing the jury that they are to draw no conclusions or inferences from that fact? It is not part of the case against you. Do you understand that?
Yes, sir.
Do you understand that if you choose to testify, you will first answer questions from your lawyer, which will generally be easier, less confrontational questions, but you will also have to answer all legally proper questions from the state on cross-examination. You don't get to take the fifth and say, I'm not going to answer that. Do you understand?
Yes, sir.
So it's questions from both sides if you choose to testify, as well as whatever questions the jurors may have. Do you understand that?
Yes.
Okay. Understanding the consequences of choosing to testify and what happens if you choose not to testify. Mr. Higginsbottom, do you wish to testify in your trial?
No, I do not, sir.
All right. I find that Mr. Higginsbottom has made his decision not to testify with a full understanding of his rights and the possible consequences of testifying, as well as the instruction I'll give the jury should he choose not to testify. He has elected not to testify. Given that decision that you've just heard on the record, Ms. Feely, do you intend to call any other witnesses?
No.
So my proposal, is that we bring the jurors back in just a moment. I'll ask you whether you will be presenting any evidence, and you'll give the answer, no, we're not. I'll explain to the jurors that then the evidence is closed. I'm gonna let them go to lunch. We'll wrap up our charge conference. I'll show you the verdict form I'm gonna use. You all will get a lunch. I have an adoption and one, I think it's Ms. Wood, not you, hopefully, one potential arraignment that we need to do during the lunch hour. And then we'll try to get back as close to 12:45 as we can. Mr. Jordan or Mr. Adkins, for closings, will you be opening and closing, or are you reserving everything to the end?
We will be opening and closing, Your Honor. ADA Atkins will be doing the opening and I'll be doing the closing.
Got it. Ms. Feely, anything else we need to talk about before the jurors come back in?
No.
Okay, let's bring them in, please.
All right, for the jurors. Mr. President, time for.
Thank you, Deputy Gordon. Counsel, you can be seated. Ms. Feely, will the defense be presenting any evidence?
Your Honor, at this time, the defense rests.
Okay. So jurors, you have not only heard the state's case in chief, you've heard all the evidence. There'll be no more evidence for you to consider when you reach the time of deliberations. I need to work through a couple more things with the lawyers so they're in a position to give their closing arguments or summations, which they're going to do right after you've had lunch. You all are going to head to lunch in a minute, and I'm going to ask you to try to be back at 12:45. That's about an hour. The state has the burden of proof, which means the state gets to open and close with closings, first word and last word. So when we get back around 12:45, one of the prosecutors is going to begin the state's closing argument. They'll stop. Ms. Feely, should she choose to give a closing, no burden for the defendant, will go next. And then when she's done, the state will get to have the last word. When all those lawyers are done talking, I'll give you the law that you must apply to the facts as you find them to be, and then you'll be able to begin your deliberations. Your deliberations do not start at lunch. Even though the evidence is now closed completely, it's not time to start talking about what that evidence may mean. You might be thinking about it individually, but don't talk about it collectively. It's still fine to have lunch together separately, however you want to do that. Any logistical questions? I learned, I don't know if it was shared with you all, that there is some food service actually in the courthouse complex. You have to go across the little bridge, or I don't even know if you can get across Pryor Street with all the barricades they have up. But it's called Fuda. That's the overarching vendor, but they bring in local restaurants, barbecue spots, et cetera. And I think they have something every day. Is that also in the cafeteria? Okay, I'm gonna let him explain all that stuff, but I didn't want you to think, dang, we've gone to American Deli 3 times in a row, and how many bad burgers can I have? It's your lunch, do with it as you see fit. Please try to be back around 12:45, and we'll take it from there. Any process questions? No? Thank you.
All right,
All right, Mr. Jordan, if you could come get, well, I'll give it to Deputy Gordon. This is the proposed verdict form. If the lawyers on both sides could look at that, you can take a seat.
No issues with the state, Your Honor.
Okay. Ms. Feely, any issues with the verdict form?
No.
Okay, let me share the jury charge. All right. I will take the highlight off that. Mr. Higginsbottom is not going to be testifying. And the only other change, if you look on the screen, you can see.
You know, I was just going to ask if the court would mind if I walk towards that screen, because this one's still connected.
Oh, yeah, I'm sorry.
No problem.
Hopefully they'll fix that someday. The bottom of page 5 and the top of page 6 have the new and arguably improved version. Let me do this just one page so it scrolls better. I can't get up in there. Well, you're going to have to just have it scroll this way. For child molestation and aggravated child molestation. So if you would look at, hold on. It'll be back. There. So take a look at, maybe I can get both on the screen at once. Yes. The primary change is adding the definition of sodomy, which is a piece of the new plain language instruction.
Your Honor, the state has no objection, if that's the right word, or believes that is the correct.
No objection.
Yes, Your
No
Honor.
objection to those two. Ms. Feely, any objection to the way in which I intend to present the offense charges for child molestation and aggravated child molestation?
No.
Okay, great. Nothing else has changed in there other than I removed all the things we talked about removing. So the presumptions is out, evidence for limited purpose evidence is out. All the things that we agreed I would be taking out have been removed. Anything else, Ms. Feely, on the charge?
No.
Mr. Atkins?
Your Honor, this is an extreme abundance of caution. I don't believe this is necessary, but I was just thinking when I was looking at the definition, which is correct, of sodomy in that charge, because this indictment involves oral, the mouth. I believe, above, I wanted to make sure, appropriately tailored to the indictment. I just wanted to think through that with the court to make sure. Yeah.
I don't think we need to put the disjunctive in there. It's not alleged that way. And so if they're going to find it, they can only find it this way, and they shouldn't be able to find it a different way. Do you agree, Ms. Feely?
Yes.
Okay, great. Also means I don't have to say that word. So, great. I will get a hard copy of the final charge, one for the defense, one for the state, for you to be reading while I read it to the jury. Mr. Adkins and Mr. Jordan, I also have a PowerPoint of the jury charge, and it will be up on the screen so the jurors can read along if they want to see what it is I'm reading to them. They'll get the hard copy during their deliberations, but while I am reading to them the charge, I also put stuff up on the screen. It's the same text. I just port it into PowerPoint. Okay? So we're okay with the verdict form. We're okay with the jury charge. Anything else from the state?
Your Honor, just would the court, would it be possible to have the final jury charges that we just walked over sent to defense counsel and I during the break?
Should mean email the Word version?
Yes, Your Honor.
Easy to do. I'll email it to everyone, but yes, I'll get it out there. But I'm going to bring you all a hard copy just so you've got that.
Thank you, Your Honor.
Sure. Ms. Feely, anything else?
It's my understanding from the state that they intend to play the jail call during closing, and so we would just like to renew our objection to that call, because the snippet that they're going to play includes the portion where it says 1 minute left.
Okay. So you don't have to object during closing. No, I appreciate that. So is Ms. Feely correct, Mr. Adkins, that the part of the call, which is states 29, that you want to replay, does have in the background or overlaying or overspeaking the words between Monique Mathis and Mr. Higginsbottom that you've got 1 minute left?
Yes, Your Honor.
Okay. All right. I overruled the objection before. I'm going to overrule it again. It's made, it's preserved, but I don't think that it's something that I need to exclude, nor do I think there's an easy technical solution for you to erase just that track from the recording. So you can play it. It will be over defense objection. I'm deeming this objection to have been timely and contemporaneously made. And I appreciate Ms. Feely doing it now so that she doesn't stand up and you have to press pause and all that. So this is preserved in any way it would need to be preserved for appellate purposes. Anything else, Ms. Feely?
No.
Okay. If you all could be back in here by 12:45, there may be some tech folks in here trying to get that to work. meaning the monitor on the prosecution desk. If you're using a PowerPoint, some of your colleagues have done some direct connect line because there's a little lag. If you are not playing a video, that's less of an issue. The slides will catch up with you eventually. This isn't the screen that's normally in my courtroom, so I don't know how direct connect would work, but you've got 50 minutes to 50 minutes to figure it out if you want a direct connect. I don't require it. I just know that some of your colleagues have found that to be smoother.
Thank you, Your Honor.
Okay. Oh, I guess I should add, if you direct connect, I don't think it shows up on all the other screens, which could be a drawback. I don't think it would pop up there and no one else is going to be able to see it, but just think through those options.
Thank you, Your Honor.
All right. I can, and I just did. Great, thank you. So when should I try to add that?
Give it a minute to start up.
I can just, I'll give it more than a minute. I want to get rolling with our trial. Though I now have no prosecutors in here.
Yeah, I'm gonna have to come back.
Okay, all right, sounds good. Ms. Sellers, are you on because of and I'm blanking on her name, we just did it, hold on.
Well,
Yes, we did her arraignment, that was at noon.
okay, all right, well,
Mr. Jordan sat in for the state, and Ms. Tidwell waived arraignment on her 3 cases. So we'll make sure whether it's you or it's Mr. Peoples, someone gets discovery to Ms. Wood so she can move forward with those. Are you holding on to the 3 cases?
is she competent now?
A doctor says so.
Okay, well, that's, I will not hold on to the cases. It will all go to Mr. Peoples.
Okay, good choice on your part. Thank you for plugging in, and fingers crossed we can just get the 3 cases resolved and move it in that direction.
All right, sounds like a plan. Thank you so much.
Take care.
Your Honor.
You too, bye-bye.
Thank you.
All right, Ms. Rivers, are you ready? We're back on the record in State versus Higginsbottom. Our lunch break is over. All our jurors here, they're ready to go. Mr. Adkins, are you ready to go as the giver of the opening part of the state's closing?
Yes, Your Honor.
Okay, anything we need to talk about first?
No, Your Honor.
Okay. Ms. Feely, anything from the defense?
Just, I'm being told that the Brady disclosure, it's in the clerk's file, but I'm being told that it needs to be part of the trial record. So we're asking the court to just take judicial notice of it and allow it to be part of the, I mean, obviously not evidence that was presented, but.
Should I make it Court's Exhibit 2? Court's Exhibit 1 will be the 14 note cards submitted by the jurors as juror questions during the evidence phase of the trial. Court's 1. Should I make that Court's 2? If I need to staple it, that's fine. If you just give it Deputy Bussey, he can get it to me, and I'll make that Court's 2. And what you're saying is that that is something that's in the docket, but it's the Brady notification that to the effect that Serenity Mathis, in her most recent interview with the state, didn't recall. Well, I'm going to call count 1 for shorthand.
Yes.
Okay. Court's 2. It's in. Anything else? Did you eat your lunch?
Yes, sir.
Excellent. Okay, let's bring the jurors in. Can I give you Court's 2 and then that's Court's 1. I don't have a way to. Sorry.
All right, Mr. Jurors. All jurors are present, count for.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back, ladies and gentlemen. I'm curious, just so we can spread the word to future juries For example, I have to pick a jury on Monday next week. Where was a popular place for lunch? The pop-up that which is down across that little skywalk.
Yeah.
Okay. All right. And it worked?
Yeah, it was a Thai Chinese.
All right. Anyone else? All the pop-up?
On the first floor, it's okay.
Okay. No one went to American Deli?
Yeah, no.
That was my last jury. Okay, that's good to know. The pop-up, some of us had forgotten about, and then an email came out saying, hey, have people use this? So good to know. We are at the phase of summations or closing arguments, opportunity for the lawyers to attempt to persuade you to decide the case in the state's favor or the defense favor, guilty, not guilty. And as I mentioned at the outset of the trial, you should feel free to be persuaded. But remember, nothing the lawyers say is evidence. If you have a distinct recollection that the witness said the person was wearing a green shirt and one of the lawyers is just really exercised about the fact that it was a blue shirt, you may just think that the lawyer missed the evidence. But don't draw your evidentiary conclusions from what the lawyers say. They are trying to pull all the pieces together to show you why it's a strong case for the state or a bad case for the state, that they meet their burden or they don't meet their burden. And that's the appropriate purpose of closing arguments. Mr. Adkins is going to go first for the state, and we'll go from there. Sir, when you're ready.
Thank you, Your Honor. 305 Banbury Drive was a house, but it most certainly was not a home. It was not a home for Serenity Mathis because of what that defendant did to her in the comfort of her own bedroom. And what you saw at this trial is the effects of what he did to her played out. And in the community, you see, we tell children to be afraid of people. Everyone thinks about someone who drives a van that they don't know, the stranger trying to offer them candy or a ride home, something to come. That's the stranger danger that kids are taught. They're not taught that the house that they live in, the house that they reside in, is where the person who is going to sexually molest them lives. And the effects of that we saw play out with the evidence and testimony at trial. And in that home, thank you, Mr. Jordan. State's Exhibit 3, that hallway, as you can see, is small. And what Serenity Mathis testified to is that that door, that last door on the far left, is where Monique Mathis and that defendant resided. And she could hear his footsteps. You could, I mean, you could stand in the middle of that hallway and touch both sides of the wall. It is right there. And that lines up with how he was able to repeatedly come into her room. And I'm sure y'all caught in the forensic interview when she said, when I confided in Monique Mathis, she said that she knew. Because she's right there along with me. That hallway should be where that bedroom should be a place of sanctity. It should not be a place of horror. And State's Exhibit 26 does not need to be an exhibit in Superior Court of Fulton County. It needs to be on a refrigerator. And why did Serenity Mathis draw stars? Because after she told Charity Alaka the totality of the sexual abuse for the first time, she wanted to be 1,000,000 miles away from her own body and where she was. So when she absentmindedly just drew something afterwards, she drew stars. That's State's Exhibit 26. Now I'm going to talk to you and equip you with the tools that you're going to utilize and follow the instructions by this honorable court when you go back and deliberate. When you got that jury summons in the mail a couple weeks ago, a month ago, you didn't expect to be sitting on an aggravated child molestation trial, but we were here. And the reason we asked all those questions at the beginning of the trial, even uncomfortable one, was to make sure that we have a fair and impartial jury. Everyone has life experiences, but we wanted to make sure that everyone could be fair for their duty. So I don't thank you because I know you didn't volunteer to be here, but I acknowledge that process and you being here today. Now, all it is seeking the truth. That is all that jurors have to do, to be fair and impartial and seek the truth of the evidence that was presented at trial. You're not to seek doubt, but seek the truth. As simple as that. Now, a lot of these things inside the circle is safe. The things you can use, the evidence, the testimony. You determine the credibility of the witnesses. Things outside the box, sympathy, whether it's for or against a witness that testified, you don't like any of the agencies that came, or you don't like the way that the Department of Family Services or anything like that, you set aside. You listen to the facts and the evidence presented and take out everything outside the box. And I'm not going to belabor these points because jurors can follow this and understand it's the facts and evidence in trial and the law by the court. That's what we're going to consider. Furthermore, so this just goes and crosses out public opinion, passion, sympathy, prejudice, for or against any parties or entities, but the legal principles. These are the tools. This is going to equip you to go back and deliberate and reach a guilty verdict for the evidence that's been presented at trial for what the defendant did to Serenity Mathis. The burden of proof was with the state, and we own that burden. But that burden, the defendant is presumed innocent, the state must prove beyond a reasonable doubt. But when the state does prove beyond a reasonable doubt, and we're back there deliberating, the state has proven. You don't have that cloak, and I like when you use a cloak. Once the state has proved beyond a reasonable doubt, you're not innocent forever. So this is what I like to use as a cloak. Someone's a Harry Potter fan, or someone likes, it's an invisible cloak. You have it, everyone has it. It's a bedrock fundamental principle of our system. For some of y'all, when you go back and deliberate and think about it, that cloak may have come off when you heard Serenity Mathis testify as the first witness. For some of y'all, it might have been when Danielle Livingston testified and spoke about what Serenity Mathis confided in her and the effects it had on her afterwards. For other of y'all, you want to wait and wanted to hear the forensic interview that Charity Alake to hear what Serenity said to her. Different parts of this trial may have been a moment in your mind where you felt that the state proved beyond a reasonable doubt because we did, and the evidence and facts of trial proved it. It's different for each person, but this is the way I like to envision it because you don't have that cloak forever. Because what happens in the dark, what happens when you think that it will never come to light, well, this is his worst nightmare because Serenity lived hers. And he never expected to have 12 members of a jury and to have all of these entities. This is, I view the Department of Family and Child Services, the Atlanta Police Department's Special Victims Division, the Georgia Center for Child Advocacy, they are the community's immune system to sexual abuse that happens behind closed doors in homes, unfortunately, throughout the county. And you heard how that response body reacts. Each step's not perfect. Just like if your body was to respond to something, each part of that is not going to be the thing that can stop it. But here it brought it to light. That's the goal. DFACS investigates so they can uncover what's going on in the home. Atlanta Police Department investigates when they get a 911 call. The school, you heard, they mandate report. It's to bring stuff to light that happens behind closed doors. You don't have eyewitnesses. You don't do child molestation in public. It's all baked into why he chose, when he wanted to, for his sexual gratification, touch Serenity Mathis on her breast, buttocks, make her suck his penis in her breast. He picked the when, he picked the why, because who would believe Serenity? And would she ever have the fortitude to come forward? And would she, Lord knows, have the fortitude to come step before and speak in public? Reasonable doubt is exactly what it sounds like. It's not a mathematical certainty. It is doubt to which a reason can be given. You can use your common sense. It's a relatively straightforward concept. It's not vague or arbitrary. It is reasonable doubt. It's not to a complete certainty. Unreasonable doubt, non-existent, unpresented evidence, conjecture, just mere speculation, that is unreasonable doubt. Reasonable doubt, common sense, and reason, not vague or arbitrary. And the state of the witnesses presented has showed you and proven beyond a reasonable doubt that this isn't just mere conjecture or speculation, because all the witnesses that you heard from, whether a small bit or a large bit, corroborate what Serenity Mathis testified to. Direct evidence. This is the most straightforward. Testament from witnesses, states, videos, like States Exhibit 24 is the forensic. States Exhibit 26 and 1 and 3 were the photographs of the home and the drawing of Serenity. That's all direct evidence. What a witness testifies to is direct evidence that you can use when you go back and deliberate and should use. What they felt, what they saw, what they heard, tangible items, which there wasn't much in this case other than the photographs and the forensic interviews. And so I show this slide. It's supposed to look cluttered by design on the bottom because all these witnesses are direct evidence. It's testimony. Now, another concept is circumstantial evidence. The law of use them is the same. So the analogy that I use is when you don't pump gas, you're using circumstantial evidence and then I can get back on the road. So you go pull into the BP or the Shell gas station, you're barely on empty, you meant to fill up gas the day before, but you forgot. You pull up just in time, you put your credit card in, and then you put the gas pump in your car. You're not watching the gas, you're not like seeing the gas come out, you don't even actually know if it's gas, you just put it in there, you wait, and when you pull off, your car drives, right? You get to go from point A to B, and what used to be empty now goes to a big F for full, and you can drive, however long your tank is of gas. That's circumstantial evidence. You didn't need to go check the credit card receipts. You didn't need to go, to the person who dumped the gas off 2 weeks ago to see was that gasoline. You just know circumstantially, you can draw reason permits that you fill your car with gas. So in this case, there's a lot of circumstantial evidence, and you have to be paying attention and see what these witnesses stated. When Assistant Principal Pendergrass spoke and said that, in fact, although Serenity was already in a developmentally delayed class, it got worse after she disclosed, and that you heard from Danielle Livingston that once she confided in her about what happened, she was embarrassed and she walked with her head down. She said, Antoinette testified that Serenity looked dead inside when she was at that home because it wasn't a home, it was just a house. But when she lives now, present day with Antoinette, she's happy, she's doing a lot better. Those are circumstantial evidence. Why was Serenity changed before the disclosure or after? You heard her tell you she felt relieved. She said that repeatedly to the people she confided in, I feel relieved to get this off my chest. Because the defendant buried inside of her and she wasn't misplaced, that Monique Mathis would not believe her or would get angry at her. That's basically what he told you. Don't tell mommy because she's going to get mad. And you saw the testimony of Monique Mathis. Date's not material. This is for obvious reasons that the law is structured. The date of when certain incidents happen did not have to be proven because it's difficult for children to address when something happened, and they may not know an exact date, and disclosures can be delayed. The testimony of a single witness, if believed, which you determine credibility, is enough to prove that element. And in this case, it's not just Serenity Mathis's testimony, either on the stand or other forensic interview, but her testimony meets every element of the charges in the indictment. But any witness, if you wanted to, when any witness that moves forward an element, some witness testified that the defendant was in the home, and he admitted that and come visit. However you utilize that, a single witness, if they bring an element or something forward, you could use that. And it's you determine the credibility, but that is a principle that you will be instructed on. Credibility of the witnesses, I ask you to think with the people you heard from, what do they have at stake? What do they have to gain? And I argue to you that there's really no witness except Monique Mathis who really has and Serenity Mathis for what happened to her, that has a vested interest in it. Certainly the Department of Family and Child Services, William Potts didn't know anybody involved in this, so she just responded to the home. Officer Martinez, his Zone 3 patrol officer, he just showed up to a call. Detective Blair, he got assigned a case. He went to investigate it. Charity Olaka, she had another forensic interview. She didn't know the defendant. She didn't know Monique Mathis. She didn't know Serenity Mathis. Daniel Livingston, they have a lot of students at Crawford in Law and Middle School. Assistant Principal Pendergrass, you determine their credibility. Was Ms. Potts, the DFACS worker who remembers this from almost a year ago, was her emotion on the stand, was that fabricated? Why was that? You determine that. You can utilize that. Was Serenity Mathis's testimony on the stand, the emotions that she depicted? Why was that? Why did Monique Mathis lie to your face when she said that she never talked about the case? And she said that she never talked to Detective Blair. Ask yourself why. Because you determine the credibility. And you can use all of that when you determine that. The charges in this case, like I started this trial with you, I explained, it's 4 counts. The first count is aggravated child molestation for the oral sodomy where the defendant put his penis in Serenity Mathis's mouth. And the other 3 charges are child molestation. For touching the buttocks, for touching the breast, and touching the vagina of Serenity Mathis. So I'm going to break this down. This is what the judge will instruct you of what to prove for aggravated child molestation. Some of these elements are quite easily proven. Serenity Mathis is under the age of 16. She testified she's 14 now. She was 13 on September 19, 2022. She's under 16. That is an element the state has to prove beyond a reasonable doubt. What the defendant did. And the best part of what, with the intent to arouse and satisfy sexual desires, right? You can infer and use common sense that when a grown man is rubbing a child's vagina, spitting on it, telling her to make these vile comments is to gratify his sexual desire. There is no even remotely reasonable explanation for any of that. Certainly not for this count, putting your penis in her mouth. But that's an element the state has to prove beyond a reasonable doubt, and you can use your common sense to infer that. Involved in an act of sodomy. Sodomy is a sexual act that involves the mouth and the sexual organ of another person. His penis and Serenity Mathis's mouth. And the best evidence of this, I'll argue to you, is State Exhibit 24.
I know you also told me he had shown his penis. Is that right? How many times, did it happen one time, more than one time? More than one time? When anything happened to his penis? Would anything like be on his penis, Would you say anything to you as he's showing you his penis?
What is the time on the for you, not like a long time. I mean, wasn't tell her when I finally told her.
Okay. But I do want to talk about, I know you said he would make you do something. What would he make you do?
Yes, chastity. And he was making me something.
He'll make you suck it? Okay. Would anything be on it? Okay. Would anything come from it? Instead of, I don't know, don't want to say, or something else?
I don't know.
Okay. Did you see anything on it?
Like something like clear.
Okay.
There was something clear on his penis. I'll argue to you, common sense, he had a condom on his penis. That's a reasonable inference you could draw from that. But that is Serenity Mathis's testimony. And as I explained to you, the testimony of a single witness, if believed, which you determined, Serenity Mathis explained that he would make her suck his penis. That is aggravated child molestation, count 1. Count 2, child molestation. It is here, Serenity Mathis under the age of 16, he touched her buttocks. And she mentioned this multiple times, when this would occur, when this would happen. Sometimes he would snap her butt, and then she said that when she was laying in her bed, he would touch her butt. And I would argue to you that a grown man touching the butt of a 13-year-old is to gratify his own sexual desires. There's not a reasonable alternative explanation for why he would repeatedly do that in her bedroom while they're alone with these other circumstances. And Serenity talks about this.
One night I was sleeping. I'm a very light sleeper.
Okay.
And I heard like footsteps to my room. And he said, he called me by my nickname. And he said, "Hey dog, are you asleep?" I said, you know people sleep.
Okay.
Yeah. I was laying down, not like all the way low, I was like this. And I was touching my butt. He doing it to me because I was younger.
Okay. And what about when he would touch you on your butt? Was that one time, more than one time?
More than one time.
More than one time?
Mm-hmm.
And can you tell me more about how he would touch your butt?
He would smack it.
Okay, he would smack it. Okay, and how would your clothes be when he would do that?
My clothes.
Your clothes.
He would
Meaning like, would your clothes be on, off, or something else?
on.
Okay, your clothes would be on. Okay. Would your clothes be on when you would touch your butt or something else?
He would be on.
Okay. Okay, so when we would touch your butt, we touch your butt on top of your clothes, underneath your clothes, or something else?
Underneath my clothes.
Then you touch your butt underneath your clothes? Okay.
And he would.
Count 2, child molestation, touching the buttocks and surrounding nappies to gratify his own sexual desires. He certainly wasn't gratified Serenity's. Count 3 is child molestation for touching the breast of Serenity Mathis. She testified to you in this trial, and she also confided in a multitude of adults that she spoke with about what happened, that he had touched her breast. And she was, the day she was disclosing the defects to Mathis, to the school and social workers, that was the day after what happened on August 31st, 2022. And for this count, it's not only in State Exhibit 24, but it's just in case you missed it.
The facts for you, please.
And then that's when he was on my bed. So I was laying down. And he touched my butt. And then underneath my shirt, it said killing on my breast.
Count 3, child molestation. And count 4 is for touching Serenity Mathis's vagina, which she testified to in actually quite uncomfortable but explicit detail on how he did that. The motion of his hands rubbing, what he said to her, the way that she described it was actually quite vivid. This count, she testified to you at trial. She talked about it to Charity. She talked about it to Ms. Potts. She talked about it to Ms. Livingston. She talked about it to Assistant Principal Pendergrass. She told me Mathis. She told her sister Antoinette Mathis. And this is the clip from when she was speaking to Charity talking about this.
Sure. Okay.
Okay. He sit on my private part.
That he sit on your private part, did I get that right? Okay.
I hear it going in circles.
And so you was going in circles?
And he was going to make me come.
You was going in circles, it was gonna make you calm.
He said it was going to make me come.
It's gonna make you calm. Okay. And what was going in circles that was supposed to make you calm?
I don't know.
Okay, did it feel like anything that was going in circles on your body? Okay.
Wait. Not like inside of my body. But he put his in the private part.
Okay.
On it.
So you put his fingers in the private part on it. I get that right?
On top of it.
On top of it. Okay. And so I do want to say this, Serenity, that everybody has different like definitions of private parts. So I want to know
My vagina.
your vagina. Okay. You say
And that's Serenity Mathis describing the defendant touching her vagina. Now, this is when I will not return to speaking. My co-counsel, ADA Jordan, will come and explain, in more detail of the witnesses and the testimony that you've heard at this trial. And when Mr. Jordan concludes his presentation, he will ask you the same thing that I asked you when we started this trial on Monday, to find the defendant guilty of count 1 aggravated child molestation and counts 2, 3, and 4 child molestation with the evidence that's been presented at trial. Thank you.
Thank you, Mr. Adkins. Ms. Feely.
Curtis Higginsbottom did not molest Serenity Mathis. I'm going to be a little bit high tech and have a PowerPoint here. When I told you in opening, it's hard to remember details of something that didn't happen. I wasn't implying that Serenity was intentionally lying to you, but she was exposed to so many outside influences, and with her limitations, she just was influenced. She may well believe what she's saying now. That's how false memory works. But it didn't happen. And the state didn't prove it. Like I told you in opening, the state's witnesses, for the most part, didn't witness anything. State's witness list, Mr. Atkins was talking about who all Serenity talked to before she talked to the forensic interviewer. That's not helpful. That's hurtful. That is showing that this interview was tainted from the start. She spoke with Ms. Pendergrass, Ms. Livingston, Ms. Potts, Officer Martinez. There was mention of a school resource officer that she spoke to. These people are not trained to speak to a child about this. In opening, I asked you to pay attention to the circumstances surrounding when this was said. You heard that Serenity was in the social worker's office because of an issue with another student. She was in trouble, and she was asking, am I in trouble? That is the circumstances under which she makes this initial statement. And then what happens? The adult reinforces, mandated reporting, you have to take it seriously. So the whole conversation shifts. She's no longer in trouble. Once it's said, it snowballs. There's no taking it back. And she talks to adult after adult after adult who's not trained to speak with children about this. And she gets more and more and more feedback that's inappropriate. So this is my only chance to address you, so I'm going to talk about the law. As you heard, the state has heard every allegation of the indictment, every essential element, beyond a reasonable doubt. It's going to seem like I'm just harping on this, and I apologize in advance, I am. And that's because this is so important to understand what beyond a reasonable doubt is. And one thing that was interesting when the defects worker was testifying is you heard that the allegation was substantiated. That sounds really serious, and it is. Down here. So that is a level of proof that is for protection. That DFACS substantiates a claim to then provide protection and support and a safety plan. So that level of proof is to support that. Here, reasonable suspicion, this is what it would take to prosecute, to move forward with the prosecution, is reasonable suspicion to get an arrest warrant for somebody. So that is slightly higher than the protection element of defects of substantiating a claim. You're now here, several steps above the arrest. So we have protection, we have prosecution, and then we have felony aggravated child molestation conviction. So if you're back there thinking that you have to convict Curtis to protect Serenity, you don't. That's already been a part of the DFACS, everything else. You've heard where she's living. Convicting Curtis is not protecting anyone. We're in a time in our society where we have, many of you have heard of the Me Too movement, Believe All Women, and that is so wonderful. Such a great pendulum swing for us as a society. Moving past what was she wearing, it's much more about protecting and supporting victims of sexual assault. And as wonderful as it has no place in this courtroom. You cannot lessen the state's very high burden of proof to get a felony conviction. So what we're talking about is if you're back there thinking, maybe this happened, that is reasonable doubt. If you are back there thinking this probably happened, that is reasonable doubt. If you're all the way to this most likely happened, that is reasonable doubt. We are talking about proof beyond a reasonable doubt. Well, let me tell you what it's not. A grave suspicion is not sufficient to authorize a conviction. So let's talk about the state's witnesses that they did bring. And I don't have a slide for all of them, because I saw you guys taking notes. You don't want to delay your time, but this is problematic. That Ms. Livingston, as well-meaning as she was, questioned Serenity so relentlessly once she made the initial statement. We don't have a recording of that. We don't know what was said, and that also is problematic. We don't know who was introducing what, but we do know that she talked to her long before the first meeting. If you are back there wondering what this conversation consisted of, that is reasonable doubt. I'm not going to pretend like it was not hard to watch her Serenity on the stand and getting emotional. She cried in the forensic interview as well for things that weren't sad. She's an emotional child. Going back to Ms. Livingston just for a second, I know the state tried to make a big deal about the fact that when Curtis was on the porch, when Ms. Livingston came to the residence, he asked what was wrong. He wasn't defensive. He was asking this person from the school just showed up at our doorstep, what has happened? It was out of concern. And then he immediately went and woke up Monique Mathis so that she could figure out what was going on while she was there. Monique Mathis told you that Serenity had been wanting to live with her sister since she was very, very young. And that makes sense because of the age discrepancy, right? So she's 26, Serenity's 14. So in Monique Mathis's mind, it doesn't really seem like the best idea for her to live with her 19-year-old sister, 20-year-old sister. Now she's 26, it makes more sense. But she always wanted to have that connection. I expect you will hear the phone call again from between Monique Mathis and Mr. Higginsbottom. Doesn't have anything to do with the accusations in this case. You can only convict if the evidence that was presented to you excludes all reasonable theories of innocence and proves guilt beyond a reasonable doubt. So let's talk about the gas station. This is not a gas station. This is not a gimmick. This is his life. And if someone with a disposition to commit such heinous acts at his age, you would think that they had done so before. And if they could have, the state would have brought other people. They have nobody else. And as we've seen, if the DA's office, particularly this week, wants to reach out and touch you, they can. This is the only accuser. State's already touched on this. This is their Dave's office favorite. This jury charge does not mean one person saying something proves a case. Testimony of a single witness, if believed by you, is sufficient to establish a fact. Not it proves an indictment, but it can establish a fact, provided you find it to be sufficient, and you don't have to. You don't have to be satisfied with just that. Don't do any outside research, obviously, but you come in here with some basis of knowledge, some of you, about how memory works and how memory is shaped. And how others' expectations can shape our memory. And how our memory can even misidentify the origin of recollection, which is what happened here. This didn't actually happen, but she was suggested it, and then it continued to grow from there and be repeated. Memory is unreliable. Eyewitness testimony is unreliable. Tons of examples and studies that some of you may have been exposed to. This is just a flippant example, but Miss Alaka, when asked about the room where the interviews take place, she testified under oath. It's got white walls and green carpet. No, it doesn't. I know it seems inconsequential, but that is how memory works. She didn't mean to come in here and say something untrue about that. And again, I understand it doesn't matter, but that's how memory works. There was no carpet. There were white walls and with one green wall. There are serious concerns about the reliability and permanence of memory. You don't have to get in her head and figure out exactly how this all happened. We know about her limitations. We know about her difficult childhood so far. And again, she may remember, she may believe it. That's how false memories work. Sorry about the small text. But speaking of people being truthful, Ms. Mathis told you that she essentially pretended to be Monique Mathis on the phone. She knew that it was Monique's phone. Obviously, they were calling for the Monique Mathis, not her. But she also told you that she was at this house every other day. She was close with her sister. She lived right around the corner. And she's the one who took her to the forensic interview on September 19th. 19 days after. I told you in opening that Serenity Mathis is so sympathetic. But as a witness, she is so problematic, particularly if you're going to face a conviction on just her word. The state had in their slide that non-existent evidence is not reasonable doubt, but it is. Non-existent evidence is reasonable doubt. It is absolutely appropriate for you to feel sympathy for Serenity Mathis, and I'm not asking you not to. But you can't face your verdict on it. You cannot base your verdict on it. The judge is going to instruct you with that. And you took an oath to do it. The judge is also going to instruct you that your verdict must be unanimous, which is true. You don't have to all agree about why this evidence is so far below proof beyond a reasonable doubt that it cannot support conviction in this case. Let's talk about reasons to doubt. If you are back there wondering what Serenity would have said in her forensic interview had she not had these outside influences, that is reasonable doubt. If you are wondering what Serenity would have said in her forensic interview if it had been within the next few days after, she still would have been subjected to all these outside influences. But if you're wondering what difference that would have made, that is reasonable doubt. If you wonder what a medical exam would have uncovered, saliva. If you're wondering what evidence could have been collected if this investigation had been handled properly, that is reasonable doubt. And it's not Serenity's fault, but it's not Mr. Higginsbottom's either. And you heard from the detective that when it was reported the next day, that would have been time that evidence could have been collected, not 7 days later when he's finally notified. But there was a window of time, and there was some physical evidence that this happened. And what evidence or lack of evidence could have been recovered or not recovered. If you wish that there was a video of what happened because you just don't know, that is reasonable doubt. If you can see how a child could just impulsively say something like this and then not know what to do next, to get out of trouble, to deflect for whatever reason, and then it blows up, she's not emotionally mature enough to walk it back. She just isn't. If it bothers you that no one else has been brought forth by the state to say he's ever even so much as looked at the body, that is reasonable doubt. So the no DNA, no saliva, no physical evidence is a problem created by the state, but it's a huge problem for my contract. Because if you convict him based on just this eyewitness, shaky, tainted eyewitness testimony, that's it. No DNA to exonerate him 20 years later. The only mention of anything in count one is in the unsworn statement given to the forensic interviewer. That's it. That should not even be, that is so far below the standards of knowledge. You didn't hear any sworn testimony, you didn't hear any direct evidence at all other than the unsworn statement. That is very much below beyond reasonable doubt. And in that forensic interview, I know you all paid close attention. She kept repeating his full name. Like, in a way, I mean, you guys are the evaluators, the credibility of witnesses. But if you were back there wishing there was anything else, any other evidence, that is reasonable doubt. If you're back there thinking that you are uncomfortable facing a conviction for a case this serious on just what you've seen, that is reasonable doubt. I don't get to address you again. So when I sit back down, I'm gonna think of 10 things I should have said to try to help you see that this did not happen and the state did not prove it. But I saw you taking notes. And I know you listened and paid attention to what the evidence was and what it wasn't. Don't let the state minimize your burden. Not proven beyond a reasonable doubt is not guilty. It's impossible for me to overstate this. It's the highest burden of proof for a reason. So we are asking you to do what you've taken an oath to do, and that is hold the state of Georgia to their burden to prove this beyond a reasonable doubt. And return with the only verdict that the evidence that's been presented to you throughout this trial supports. And that is not guilty on all counts.
Thank you, Ms. Feely. Mr. Jordan, you've got about 35 minutes left
Yes, Your Honor.
when you're ready.
Brain dog, are you awake? Your pussy is so wet. I'm gonna make you come. I'm gonna make you feel good. Those were the words that the defendant, Curtis Higginsbottom, said in the ear of a 13-year-old girl before and during him violating her. Ladies and gentlemen, this is the state of Georgia versus Curtis Higginsbottom. And those vile, monstrous words that I just came out of my mouth are the reason why we're here. This is not the state of Georgia versus Monique Mathis. This is not about Danielle Livingston doing her job. This is about the defendant choosing his victim and being the monster next door and violating her for a period of 3 years. That is why we're here. The reason why we put up Serenity Mathis as the first witness is because she needed to tell you why we're here. Every witness following that was telling you how we got here. And that is extremely important for you to be able to base your verdict in this case. And I might as well talk about it now, ladies and gentlemen. The defense has a lot of theories, a lot of distractions, but they're just distractions. They showed you steps twice in their presentation to talk about all the steps that it takes to get to reasonable doubt. And reasonable doubt is a high burden, it should be. But what I would present to you, what Mr. Atkins and I would present to you is that if you keep walking up those stairs and you're not paying attention to the actual matter at hand, you're gonna lead those stairs to nowhere. You're just gonna continue walking. If you're looking for DNA, if you're looking for, is the social worker doing too much? The exact words of Serenity Mathis here in this courtroom as she sat right there, and in that forensic interview on September 19th of 2022 are the reason why we're here. Everything else is just a distraction. And I would implore you to not follow it. Let's talk about the witnesses that we heard from. You learned a lot about Serenity, that her mom died very early in her life, that Monique Mathis raised her. She has one sister, Antoinette Mathis. She's in special education classes. You got to see where her room used to be. You got to see where she lives now. You got to see her pets. You got to hear from assistant principal Andrea Pendergrass. Now, what did we learn from Ms. Pendergrass? We learned that she had been at Crawford Middle School for 4 years. We learned that Serenity has an IEP. She will often ask if she's in trouble. This whole theory about being in trouble and that just this allegation about Mr. Higginsbottom was just her golden ticket of getting out of it, that would be a great theory if she didn't do that all the time. If she didn't do that in the forensic interview with Charity. And we also learned that since this incident, she's gone backwards intellectually. She's been placed in a whole other class. She started out in special education. We learned that on September 1st, that Serenity Mathis told the assistant principal that her uncle had touched her private parts. And she did her job, ladies and gentlemen. Andrea Pendergrass and Danielle Livingston did their job. They were familiar with Serenity Mathis. No, they weren't trained professionals, but we got to see Serenity Mathis testify. We saw how slow she would be to answer that. She has a developmental delay. The reason why that particular conversation took 2 hours is because she speaks slowly, she has a delay, and she was saying the most uncomfortable thing that she had undergone in her life. And she told Monique Mathis to contact the police to report the molestation. Now, what did we learn about Danielle Livingston? She works as a social worker at Crawford Middle School. She's been working with children for almost 30 years. She was told by Serenity that Curtis Higginsbottom had touched her private parts and said something inappropriate in her ear. And as I just stated, it took close to 2 hours to get this information from Serenity. Not because she was trying to pull it out of her, because she could see that that little girl was troubled, that she was upset on that particular day. She tried to call Monique Mathis with no answers, and she went to 305 Banbury Drive and was greeted by Curtis Higginsbottom, whom she did not know. She had no idea at that particular point that it was Curtis Higginsbottom, but she told Monique to call the police. Ladies and gentlemen, once again, she did her job. She did what she was supposed to. She followed protocol. Now let's talk about Monique Mathis. I know we all got to see her sit right here. We got to see her demeanor. We got to see the way that she answered my questions. We got to see her testify about the little girl that she had raised since she was a couple weeks old, with no feelings of anything towards her. Nothing. We know that she shares a child with the defendant, whether she came in and told us that it's not his biological child, but it is his child. She's the girlfriend / wife of the defendant. She was told by Ms. Pendergrass and Ms. Livingston that Serenity had been molested. Now, ladies and gentlemen, in just a second, I'm going to play for you the 911 call. I don't know if you caught this the first time that we played it, but listen to the language that she uses when this is her first contact with law enforcement, her very first time. Listen to the words she uses.
Turn the sound off. Oh, yeah. Just go back into my more.
That's an hour 1 operator 8142 is the address to your emergency. 305 Danbury Drive, Southeast Atlanta, Georgia, 30315. You said Danbury Drive? Yes. Okay, you need 5 police and EMS. I just need, police, law enforcement. Okay, what's going on? I just need, report something about my niece. Okay, what's going on there? She's been allegedly touched by my daughter's father. She did what? She was allegedly touched by my daughter's father. Okay, so she was possibly raped or molested? No. But that's what it's. Okay, yeah, that's what it's pertaining to, yes.
Ladies and gentlemen, I don't know if you caught that, but she used the word allegedly twice. Twice she used the word allegedly. Now, in my field, we use the word allegedly a lot. Legal professionals use that. Someone that's in the media may use that. Not the caregiver of a 13-year-old girl with developmental delays that's in a special education class. She chose her words very carefully there. And even when asked, is this dealing with a molestation or a rape? She said no, and had to be corrected.
After 911.
Ladies and gentlemen, we administered and tendered into evidence State's Exhibit 15, but we only got to see a small clip of it. But I want to go forward a little bit in my presentation. When you listen to Ms. Mindy Paylor talk about the effect that a non-supportive caregiver can have on the disclosure, this is exactly what we were talking about. When speaking to the officer who came to 305 Danbury Drive, she yells at Serenity while she's trying to recall details about how she disclosed the molestation.
Work in the school.
What about you tell? I told
Teacher.
the school social worker. Social worker.
You know her name? You know her name?
Yes.
Yes.
What's her name? Miss who? Oh, Miss her. Okay, I told Miss actually. What name? I told Miss Pendergrass.
Pendergrass.
Ladies and gentlemen, I would present to you today that there could not be a more perfect picture of what a non-supportive caregiver is. She's trying to disclose details about who she told the molestation to. She's being yelled at and berated in front of a police officer. Now let's talk about her testimony. She testified the defects worker was so rude. I hope you all remember Ms. Potts. Ms. Potts met Serenity Mathis one time. And I hope you remember when she got on the stand and had to testify about what Serenity Mathis told her, it brought her to tears. She met Serenity Mathis one time, and that defects worker was so rude. She said he was at the home and outside the home. Ladies and gentlemen, you know, we speak differently, we come from different places, but when I want to say that someone's not here, I say they're not here. I don't say they're outside the home, they're on the grass, they're inside the home. I didn't talk to Detective Blair. You know that that wasn't true? You heard that audio call of Detective Blair speaking to her. I don't talk to Curtis about evidence in this case. And Ms. Feely may have telegraphed this one, but I know that unless you had supersonic hearing the first time that we played this in court, you probably weren't able to make it out. So we fixed our audio issues, and I want you to be able to listen to that call.
And went down there. They went down there today.
Who went down where?
You know, the people, both of them, they went down there today. Examining the courtroom and shit like that. And so it's 4 people from the crew supposed to be going there saying what they gotta say. Me, her, and the girl, boo-hooing and all this other stuff. They just showing pictures. They the police that came had his camera on, and they was like they got the video of that. Cause it's the man that called the phone when she had it when she came in.
Yeah.
They had that. They was like I was playing stupid. I didn't know who I was talking to. And I was like, no, that ain't true. I was at the outside? No. Oh. And so they was like, all this other dumbass shit. Come out, they put the two people that was there involved. They was like, when they confronted you, you act like you was scared. Come out, her dude or whatever. And then I haven't talked to nobody. I know, I'm talking about when they came in there, remember? Yeah. And they was like, you did and all this, that shit was recorded. I don't know how, I don't know what was said. I don't know how that shit was recorded. Somebody was on the phone when they pulled up and the principal was like, she left me at the school and I caught a ride home and all this other stuff. Oh yeah. You was on the phone when they pulled up, you was asleep. I had to wake you up, honey. No, I'm talking about when I went to the school. Remember when they took me to the school? And they was like, they was in that U-Haul and all this other shit. It's about to be messy.
It's about to be messy. That pretty much sums up the testimony of Mindy Paylor, ladies and gentlemen. Now, she was told to not have Curtis Higginsbottom come back to the house while Serenity was there. But we already know, we heard that he was there on September 1st. He was there on September 7th. He was there again in November. Now let's talk about Antoinette Mathis. She first learned about the molestation on September 7th by mistake after answering a phone call intended for Mindy Mathis. Now the defense made a big deal about her giving false information to a police officer. Ladies and gentlemen, what would have happened if Antoinette Mathis didn't pick up that phone call? We heard that Monique Mathis didn't bother to tell Antoinette that her sister had been molested. She testified that when she heard the news on that phone call, it broke her heart. Now I want you to think about the juxtaposition between it broke my heart, allegedly. Was she raped or molested? No. She immediately confronted Monique and Curtis. She said Curtis looked nervous during the confrontation. She also identified the defendant, Curtis Higginsbottom. She's had custody of Serenity Mathis ever since. Let's talk about the investigators that investigated this case. Now, we talked about Ms. Potts already. She did speak with Serenity Mathis. She told you exactly what Serenity told her on that particular night. She became emotional on the stand recounting what Serenity had told her. And most importantly, ladies and gentlemen, she had Monique sign a safety plan on September 1st that she violated within 6 days. It wasn't a full week before it was discovered by defects that Curtis Higginsbottom was still at that house. And here's State's Exhibit 15. You can see that safety plan right there. Let's talk about the officer. He was dispatched to 305 Granbury Drive in response to the 911 call by Mindy Mathis. He was the first to interview Serenity Mathis. And this is what Serenity told him.
So what he did?
Like, he said, it's like, I'm gonna make you calm.
Okay, he has requested you that you calm.
Yes,
Okay,
and you calm.
okay.
And he said, no. And he said, and then he did it aggressively.
1309. I copy. Okay, what area he said that moving that one?
Serenity Mathis was able to disclose that with her aunt, who had just screamed at her a few minutes earlier. She was still able to tell the officer that Curtis Higginsbottom said to her, I'm gonna make you calm. Now, we also heard from Detective Blair, trained to investigate child sex crimes, called Monique Mathis. He also told Monique Mathis that Curtis should be in the home. and he referred Serenity for a forensic interview. He found out that the defendant wasn't there, so he didn't interview. And ladies and gentlemen, you heard the forensic interview. Detective Blair sat there live and watched as it's happening. And all of those words that are on the screen right now, if they make you uncomfortable, I understand. Let's talk about Charity. She is the one trained professional that Serenity Mathis spoke to, the one trained professional. And the defense made this big deal about speaking to multiple people. Ladies and gentlemen, the most details were disclosed in this forensic interview. This is where she felt comfortable to say that Curtis Higginsbottom took his penis and put it in her mouth and made her suck it. This is where she disclosed that this has been happening to me since 2019. She estimated that she was 6 or 7 years old. This environment, not the courtroom, where she had to sit here and sit in front of 12 people that she does not know. This environment is where she disclosed everything that happened. And the defense wanted to say that, the introduction of the word penis was a big deal. Mindy Paylor was very honest in her critique of Charity. She said that, yes, that was an introduction of the term. But ladies and gentlemen, it was not an introduction of the act. No one planned that act in Serenity's mind. She said it came out of her own mouth that happened.
For like a long time. I didn't want to tell her, and I finally told her.
But I do want to talk about, I know you said he would make you do something. What would he make you do?
Yes, Chastity. And he was making me see something.
He'll make you suck it? Would anything be on it? Okay, would anything come from it? That I don't know, don't want to say, or something else?
I don't know.
Okay. Did you see anything on it?
Like something like clear.
Okay. Something clear? Anything else besides clear?
Like that.
Okay. Okay. Where do you see the clear at?
On this part.
Okay. Okay. And what would make him stop having you touch his private part?
I didn't touch it, he would make me.
Right. What would make him stop having you touch it?
When we came.
Ladies and gentlemen, we heard from our expert witness, this Mindy Paylor, who trained Charity. She explained to you delayed disclosures. She explained how disclosures are affected or may be affected by a non-supportive caregiver. She told you the difference between forensic interviews and therapeutic interviews. And she told you that disclosing more details to certain parties is a part of disclosure. It's a part of the process. It's not about, I want to tell this person this, and I want to tell this person this. As I said before, one trained person spoke to her, and she gave that person all the details. Most importantly, she told us about multi-episodic abuse. We heard from Serenity, this has been happening since 2019. So she may not have quite as much detail as she had about the events that took place on August 31st. Ladies and gentlemen, I would present to you today that August 31st of 2022, or September 1st, rather, the day that she finally told individuals at Crawford Middle School, was the day that the dam broke. Serenity could not take anymore. She had wanted to tell Monique Mathis. She wanted to get it off her chest. She has developmental delays. You can see in that forensic interview, which takes place 19 days, as the defense said multiple times, 19 days afterwards, she's still very much in the shadow of living with Mindy Paylor, living with Curtis Higginsbottom. She, heartbreakingly, she says, I still love Curtis. I love Monique Mathis to the bottom of my heart. That's only a few weeks after she's out of that environment. And it's heartbreaking to hear her say that, because that man violated her. Over the span of multiple years, he violated her. And she also told you how trial testimony in a public setting where strangers can even affect what she's going to say. It's not easy. It's not easy for grown adults to be on that stand. It's difficult. It's difficult for anyone, let alone a 13-year-old child, or who is now 14. Ladies and gentlemen, as I bring this to a close, I want to harpen as much as I possibly can to you, because the defense has talked about DNA, they've talked about specific things. They want to distract you. They want to keep your eyes off of what is right in front of you. There's a reason why there's no DNA. The defendant chose his crime. There's not going to be any DNA from touching, especially when we receive multiple excerpts of testimony that he lived in the house. Even if he comes and goes, he's there often. We never heard a different address for him. We never heard a different place for him other than 305 Danbury Drive. He chose his crime. He chose his victim. He chose Serenity Mathis. He knew the dynamic between Monique Mathis and Serenity. Serenity said in her forensic interview, she used the word secrets. She said, don't tell mommy, mommy will get mad. And guess what? Mommy did get mad. She got mad at Serenity. She got mad and she started to use words like allegedly. She started to use specific phrases. She came here today, or a few days ago, and was angry. She did get mad. And Curtis Higginsbottom knew that. He used it to his advantage. He used that so he could abuse Serenity Mathis. And he chose his timing. One of the reasons why Serenity Mathis's testimony and her forensic interview are so powerful is because the contextual details that she has are supporting her. She remembers Ring Dog. She remembers it was nighttime. She remembers him coming in and out of the room. Those are all contextual details. But ladies and gentlemen, the defendant chose wrong. He did not expect her to come forward on September 1st of 2022 and let the people at the school know, my uncle touched me. My uncle has been abusing me since 2019. And Mr. Atkins already said this, but he didn't expect the 12 of you to be able to look at the evidence and be able to decide whether he's guilty or not guilty. He didn't expect that. He chose a crime where there was not going to be any DNA, there was not going to be any video evidence. He chose his specific way of touching her. And I hate to harp on it, but you're not going to be able to get, what does a saliva test from something that happened in 2019 prove? What's that going to say? It's another opportunity or another chance for you to get distracted. But Serenity Mathis provided you with what you need. Assistant Principal Andrea Pendergrass provided you with what you need. social worker Danielle Livingston provided you with what you need. The defects worker, Ms. Potts, provided you with what you need. Detective Blair did his job. Officer Martinez did his job. Antoinette Mathis took that phone call and did what a caring, supporting sister is supposed to do. And that, ladies and gentlemen, is the reason why we're here. And we talked about this already. The testimony of a single witness, if believed, is sufficient to establish a fact. And we talked about the counts already, and I just want to make you aware of Serenity's statements. For count 1, Serenity said he would make me suck it. He had a clear item on his penis, which, as Mr. Atkins had already said, is a condom. Or you can use your rational thinking to infer that that is a condom. He came to my room and showed me his penis multiple times. I've been wanting to tell her, and I finally told her. Don't tell mommy will get that. We heard count 2 in the video that Mr. Atkins already presented. We heard Serenity say, Curtis touched my boobs. She motioned towards her chest in the forensic interview. We heard her say that he aggressively took my underwear off. He spit on my private part. He whispered in my ear, I'm gonna make you come. He touched in a circle. She provided details. And this is the timeline of events that you already know. That on August 31st of 2022, that Serenity Mathis was molested by Curtis Higginsbottom. She went to the school, talked to the teachers, said Curtis touched me, and described the details. If you're wet, I'm gonna make you come. And on August 22nd of 2023, Serenity completed her testimony and came before you and told you exactly what happened. So ladies and gentlemen, I would implore you and tell you that you are authorized by all the testimony that you have heard, by all of the vile, horrendous, predatorial statements that you have heard come out of Curtis Higginsbottom's mouth, per Serenity Mathis' testimony, that he is guilty of aggravated child molestation, count 1, that he is guilty of child molestation in count 2, that he is guilty of child molestation in count 3 and count 4. So when you go back to the jury room to deliberate, we would ask that you find him guilty of all counts. Thank you.
Thank you, Mr. Jordan. So ladies and gentlemen, you can take a break right now for about 15 or 20 minutes, or you can stand up for a second and shake about a little bit, and I can read to you the jury charge. If we do it the second way, short break, and then you get the case, you can start your deliberations when you get back into the jury room. But you just listened to 2 closings, kind of 2.5, because there were 3 lawyers. I want to make sure you're ready to absorb the jury charge. Let me tell you the format real quickly. It'll be up on the screen as well. And this document that I'll be reading to you from which I'll be reading to you, will go back with you during your deliberations, just like the indictment. So you'll hear me say it, but you can also hold it and read it later. So that said, is there anyone who needs the longer break now? Seeing no hands, why don't you just sort of move around a little bit while I get the PowerPoint on the screen, and we'll do the jury charge, and then you'll be able to begin your deliberations. Are you okay? You do, okay. Deputy Gordon, Mr. Alexander is up. Okay, his lawyer was just here and stepped outside, but you let him know we'll deal with that as soon as we finish this. The prosecutor's online. Thanks. We're just waiting for the court reporter to come back. You good? Okay. So ladies and gentlemen, in just a moment, I will share with you the jury charge, the law that you must apply to the facts of this case. As I've already told you, you'll have the document from which I'm reading back in the jury room. If you are someone who likes to see what you're hearing, the words will be on the screen as best I can keep up by scrolling through the pages. Some of the language may seem a little arcane, and for that, I apologize. There's certain legal concepts that I'm required to explain to you using specific words according to either our legislature or our appellate courts. But when possible, I try to make the language as accessible as can be. So hopefully it's not too legalistic. And with that, you should know that a grand jury has indicted the defendant in this indictment that you'll get for aggravated child molestation and child molestation. The defendant has entered a plea of not guilty to these charges, and neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with the defendant until or unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. And I'll be giving you the elements of aggravated child molestation and child molestation a few pages into this document. There's no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. A reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you may convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I am giving you to the facts that you find. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony and exhibits, documents, videos, audio. Evidence does not include the indictment or the plea of not guilty, anything said by me or the lawyers to include their opening and closing remarks, nor any questions posed. The evidence you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. Someone walks into the courtroom with an umbrella and it's wet, it's shaking the umbrella off. That might be circumstantial proof that it's raining. You don't know, there are no windows in here, but people coming in with umbrellas that are wet might be circumstantial evidence that it's raining. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility of the witnesses, the believability of the witnesses. In deciding this, you may consider the evidence, the witnesses' manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider other evidence offered to attack the credibility of witnesses, to include evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You have heard from a witness who was designated as an expert. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all other witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. Defendants who have no burden to prove anything are not obligated to testify. Where, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. A crime occurs when the law is violated by a defendant's intentional action. And criminal cases such as this must be tried in the county in which the crimes were committed. This question of venue, that is, was the alleged crime committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but it means simply the intent to do the thing that happens to be illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of the act. A defendant is not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from consideration of words, conduct, demeanor, motive, or other circumstances connected with the acts for which the defendant is being prosecuted. For child molestation, the state must prove three things. The state must prove that the defendant, 1, committed an immoral or indecent act, 2, to a child under age 16, 3, with the intent to arouse or satisfy the sexual desires of the defendant. For aggravated child molestation, the state must prove that the defendant, number 1, committed an immoral or indecent act, 2, with a child under age 16, 3, with the intent to arouse or satisfy the sexual desires of the defendant, and 4, the act involved an act of sodomy. And in Georgia, sodomy is a sexual act involving the sex organ of one person and the mouth of another. Considerations of consent and force are irrelevant in child molestation cases. Children under the age of 16 are legally incapable of consenting to sexual acts with adults. In proving the date of a crime, the state is not restricted to proof of the dates alleged in the indictment. Ladies and gentlemen, you should consider each count of the indictment individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, which is almost complete, you should unanimously find beyond a reasonable doubt that the defendant did in Fulton County commit any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. And on the verdict form, which I'm holding in my hands, for that offense, you would check guilty. And for each of the 4 offenses, there is an option of guilty or not guilty. If you do not believe that the defendant is guilty of an offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And on the verdict form for that particular offense, you would check not guilty. Whatever your verdict is for a particular count, it must be unanimous. Your verdict form must also be in writing, signed by your foreperson, and dated. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws that I have given you. It is your duty to consider the facts objectively without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You all are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs when you very soon move to the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any further research. In fact, you haven't done any research at all. No research then, no research now. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with this instruction, Deputy Gordon or his colleague will be collecting all your electronic devices while you deliberate. You'll get them back, I promise. But while you're in the jury room talking about this case, your machines will be beeping and doing things in my chambers. We'll get them back to you when you're done. Going forward, should you need to communicate with me for any reason, it must be in writing. Upon receipt of your question or note, whatever it is, I'll confer with the lawyers and share with you whatever response I am allowed by law to give. And that last caveat is in there for a reason. Sometimes you ask a great question and all I can write back is you're going to have to rely on your collective recollections. Like I told you at the beginning, we can't give you a transcript of a witness's testimony. If there's an exhibit that you thought we were going to give you and you didn't get, put that, hey, where's exhibit 10? If there's something you need to listen to again because there was a recording that got admitted, let me know. If you've got legal questions, I'll do my best to answer within the confines of the law. That, ladies and gentlemen, is the charge of the court. In a moment, I'm going to ask you to retire to the jury room. And as soon as you get the jury charge, this verdict form, this indictment, and the exhibits that were admitted, you can begin your deliberations. You can get started by picking a foreperson. And then when Deputy Gordon delivers that packet of materials I just described, you can start your deliberations. Before you go back there, I need, of the 14 of you, for Ms. Koppel and Ms. Walsh to stay put. The rest of you go on into the jury room and start handing over your Apple Watches, your phones, your iPads, etc.
All around the jurors.
You two are alternates. You were here because we needed you here. If we lost a juror, you wouldn't have known it. But if one of the jurors who wasn't you, you all can be seated, had to go, you would have invisibly slid into a non-alternate role. We need you to stick around today at least, because if we lose a juror during deliberations, then one of you is going to slide in as a deliberating juror. The two of you are going to be in our other jury room. You get to keep your electronic devices as long as you don't do any outside research. Don't talk about the case amongst yourselves. I promise we won't forget about you. If this jury goes home at 5, you go home at 5. And before you go, we'll talk about whether you need to come back tomorrow or whether you can be on a warm standby. If you can get down here on pretty short notice, you can go about your business tomorrow if we don't get a verdict today. But you will remain on call until the jury is done deliberating, because you could be patched in at any moment. So if you have belongings in the jury room, go grab them. You can take your notepads and your belongings, and Deputy Gordon will get you set up in that room. As I said, I promise we won't forget about you. If we finish today, eventually all 14 of you will get back in the jury room and I'll release you. Okay? All right. Thank you. Mr. Adkins, were there any exceptions to the charge?
No, Your Honor.
Ms. Feely?
No, Your Honor.
Okay. Mr. Adkins, have you and Ms. Feely discussed which exhibits go out and which don't?
We have not, Your Honor, but we can do that right now.
Why don't you start having that chat?
Yes, Your
Thanks.
Honor.
Ms. Feely, can I hand you, please, through Ms. Rivers? That's the indictment, jury charge, and verdict form. Can you put the verdict form on the top just so they don't have to hunt for it? Ma'am, you came in with Mr. Reeves. Do you work with him? Is he nearby? Great. Okay, we're about ready to start. Did you bring a copy of the warrant or did you need me to print it out? Me print it out? So you didn't come prepared. Can you remind me of your LT, whoever I sent it to? I need to find the email I sent him.
It's Smith, Carter.
Nah, what was the last name of the guy who forwarded me?
Carter.
How do you spell that?
Cottor.
Okay. There it is. So you reviewed it and it does what you needed to do? I tweaked it a little bit. Okay. Before Deputy Gordon goes, let's get on the record briefly, please. Mr. Adkins, were there any disagreements as to what goes back with the jury?
No disagreements between the parties, Your Honor.
Okay, you agree, Ms. Feely?
Yes, Your Honor.
All right, thank you, Deputy Gordon. You okay? The officers, I'm with the officers. Oh, I don't know. If I could please have a phone number for both sides, just put on one note card, one number for the state on that same note card, a number for the defense that we can call when we need you back in the courtroom.
Yes, Your Honor.
Okay. All right. Mr. Higginsbottom, you will be brought back into court anytime there's a juror question, anytime we're talking about your case, you'll come right back out here. While they're deliberating, you'll be there. Okay. Mr. Reeves, are you ready?
Yes, Your Honor, I see the sign, Mr.
Tell me what the new charges are. I haven't opened it yet. It's been reduced, I assume.
Yes, it's aggravated assault, false imprisonment, misuse of sexual battery.
Okay, and what's the joint recommendation?
15 years to serve 10.
Okay, I'm okay if you don't sign them up. I think we can make a sufficient record if you're all right with that. Just that way we can keep, I know we're 45 minutes late for you.
Okay.
Okay. So if we could bring Mr. Alexander out when you guys are ready. I know you're shuffling a bunch of things.
You want us to clear the table, Your Honor?
Just 1 second. Who's that? Adkins handwriting? 1743. Thank you. Okay. All right. Yikes.
Another life on the doctor, Your Honor. At least handwriting wise, not intelligent.
Yeah. Mr. Jordan, you stay where you are. Ms. Hall is online, so you guys don't need to move. And Mr. Reeves and his client are going to be at the podium. So Ms. Feely, you can stay where you are.
Thank you, Your Honor.
Investigator, I'm printing the warrant out. Do you have a few more minutes? Because I'll probably do this plea and then swear you in. You good? Okay. Ms. Rivers, do you have, it's an accusation. Do you need that case number? You ready? It's 23 SC 189043. Ms. Hall, are you ready?
Good afternoon, Your Honor, I am.
Great.
When Mr. Alexander does come on, if I may just have a moment to show him the accusation. since
Sure.
he's got it. Patrick Alexander.
You know what I'm gonna do is I'm gonna print it out and we'll just get his John Hancock on that.
Okay. Thank you, Your Honor.
Sure. Okay, tell them to keep going for now.
Before we begin, could you do that? Are you moving? Yeah, as soon as we get it off.
Deputy Gordon, can you give this to Attorney Reeves, please?
All right, I just have a moment to explain the accusation to Mr. Alexander in that.
Okay. Investigator Gonzalez, why don't you come on up? We'll seize this opportunity. All right, do you swear or affirm that the contents of your affidavit are true and correct to the best of your belief and understanding? All right. If you sign right there, you're the affiant. And how are you, sir? Oh my gosh, it was the no hair. I was like, where is these close? It's Burns. There used to be a little more and it wasn't quite that color. How you been? Are you working with him now? Sheesh. So you out in the forest a lot too? Last time I was talking, I was like, I'm in the forest. Okay, well, great. Are you going to be assisting in this little project?
Yes, I think so.
Okay, good. All right, and I signed the other party provision that lets you get folks out as well as search employees. Only employees, you need separate PC to search a non-employee. Let me put this for you and good luck with all that. Wasn't sure I'd ever see you again. Just sort of went, I sent it back to Cotter and didn't hear anything. I'm like, ooh, I guess they did something.
Yeah, I'm sorry.
No?
For me that he had received it.
Okay, I was fine. I was going about my business.
Right.
All right, see you guys. Be safe. Good seeing you. Do we know where the lawyers went? Because we could knock this out while they're having to yap. If they're not right outside, don't worry about it.
If I just did.
Okay. Are they not able to pick a 4-person because of this? Or, okay, all right, good. Okay. Can you check on them, please? I do.
Needs more time, right?
All right, Ms. Hall, are you still with us?
Yes, I'm still here, Your Honor.
Great. So, Mr. Alexander, it sounds like we're at a little bit of a crossroads. I was under the impression that you were prepared to enter a negotiated plea to some pretty seriously reduced charges. But that's your call, not mine. If that's not what we're doing in the next couple minutes, I got to turn to my other stuff to include this trial that's happening right now. And on Monday morning, we'll pick a jury, not with these new charges, but charges that carry, I don't know about your criminal history, possibly life without parole. So I just want to make sure you're making a thoughtful decision. I suspect you are, because you and Mr. Reeves were taking some time to chew on this, but you filed a detainer, which means I got to move your case. And there are no breaks, as in I can't slow it down. So it's either we sort it out today, or on Monday morning, we'll pick a jury, not in the case I had brought in behind yours, but in yours. And I'm assuming, I'm going to let Ms. Hall make it clear on the record that the state would be going forward with rape, aggravated sodomy, et cetera, which is a different ball of wax from this accusation that removes those that are the 25 years mandatory, no parole, possibility of life without parole. Do you understand the crossroads you're at?
I understand the crossroads. I've been here for 2 months. This plea was brought to me like last week, and I never was able to see this paper and read it and fully understand it. And it's just like, it's a rush deal. It's like 5 minutes. I'm finna make this decision.
And they're big decisions. I hear you.
Which I wanted to contemplate on making. If I have no other choice, then
No.
I don't understand the plea fully.
Well,
Okay.
Your Honor, if I may, just kind of further expound on where Mr. Alexander's coming from. I have been working with the state. We've been trying to figure out a resolution to this. We did finally come to a resolution that I presented to Mr. Alexander last week. As you say, these are serious charges, and I'll just, put on the record, I know the state can do this as well. He does have 2 prior armed robbery convictions, so his exposure is looking at mandatories of life without parole if convicted on counts 1 and 2. And based on that, we came up with this resolution that would be parolable. As I stated earlier, it's 15 years to serve 10 years. And when we went over that, Mr. Alexander has always maintained his stance on this, but when looking at his exposure versus the risks of trial versus taking a guarantee with a plea, he was leaning towards the plea. I think his biggest issue is wrapping his head around the language in the indictment and understanding that even if he were to plea, pursuant to offer, it's still a guilty plea, and he's still pleading to these facts as alleged in this accusation that he did just get a few moments ago. And so I think he's asking for some additional time to contemplate it, but I understand the court's on a schedule, and either way, we're going to have a trial or a plea on Monday.
Right. So I want to make a couple of things clear if I didn't, and I apologize if I was unclear. You, through your lawyer and the state, can continue talking. It may be that Ms. Hall, I want to let her talk in just a moment. It may be that Ms. Hall is willing to leave this offer open, but the state's going to need to get ready for trial on Monday as well, which means starting to move heaven and earth to get rolling. And that may mean they withdraw this offer. And what you get Monday morning, if you come in saying, I've thought about it, I prayed on it, whatever it is you do, but I don't want to go to trial because I don't like the risks of going to trial. It may be that Ms. Hall says, okay, now it's 15 to serve, or it's 20 to serve. And you don't get to rewind the time and say, but wait, what about that 15 to 10 that I learned about a couple of weeks ago? And I didn't see the parameters of it till now, but Mr. Reeves is saying that the numbers we're talking about, maybe you had heard about before just today when you saw the document. Is that a fair statement? Yes?
It is.
Okay. Ms. Hall, what is the state's position on whether this offer stays open after today or what?
Oh, thank you, Your Honor. Well, this offer expires after, if we don't take a plea today, then there goes the offer. As you know, Your Honor, I've been out, and so I was working on this case while I was out of town. And I stopped prepping for trial when we came up with this resolution. So so that I can prep for trial and not have to go back and forth with whether or not we're taking a plea. we're gonna take the plea off the table once your court session ends today.
Okay, well, I can offer this up. I'm not available tomorrow, so there wouldn't be a plea tomorrow. And it sounds like if we wrap up today, and Ms. Hall, doesn't leave with this having pled out, then the offer's off the table. I need to get the jury back out here in a minute, and then I've got something at 3:30 and at 4, but I should be done by 4:30. And I don't mind seeing if at 4:30 we can take the plea. That's an hour and a half from now, which is sometime. But Mr. Alexander, I want it to be crystal clear. I'm not applying any pressure. If your stance is, I need a night to think about it because I got to call some people and all that, I respect that decision. But that would mean I see you Monday morning, and that means we're getting ready for trial. You're getting ready for trial. And Ms. Hall has made it clear on the record, if we all say good night tonight and head different ways, then this offer and the plea to this accusation isn't something that they're extending anymore. Do you follow all that?
I follow.
Okay. So tell me what you'd like to do. Do you want more time today? And I'll take everyone's pulse in about an hour and a half. Or do you know that's not enough time and we ought to just make plans to get you here on Monday?
Well, it's not enough time, but I believe that it is what it is. I'm just gonna take it. It is. I'm gonna accept the plea offer or whatever.
So you want to go forward right now?
Yeah, it is what it is.
Okay. Well, why don't we make a record of that? And until I pronounce sentence, you are free to change your mind. I want that to be clear too. So we're going to have further conversation. And if this starts to reach a point where you want to reconsider again, there are a couple of checkpoints when Ms. Hall will ask, how do you plead? And you may say guilty under Alford, all those things. But it's not until I say I accept your plea and pronounce sentence that you're locked in.
All right. Am I gonna wake up now?
Yeah.
We good?
Yes, Sean.
Okay. Then let's get started. Mr. Alexander, in a moment, Ms. Hall is going to put you under oath. She'll do that by having you raise your right hand. Once we get going, Ms. Hall will have some questions that are primarily about your rights as a criminal defendant. I may have a few questions as well. You may have questions, and it is very important that you let Mr. Reeves or me know if you've got a question. If something isn't making sense, or wait a minute, I need to talk to Mr. Reeves about that, tell me. And we'll take that time out either so I can answer your question or the two of you can speak in private. Will you do that?
Right, I will.
Good. Okay. And importantly, your answer to any question needs to be out loud. You're welcome to nod your head, shake your head, but you need to use words too, because the court reporter can only take down the spoken word from you or from your lawyer. All right?
All right.
Great. Ms. Hall?
Thank you, Your Honor. Ms. Alexander, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
I affirm.
You may lower your hand. Please state your true, correct, and legal name.
Patrick Alexander.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I'm not.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 34 and I have a GED.
And are you able to read, write, and understand the English language?
I am.
And Your Honor, for the record, at the end of this plea, the state's intention is to null process the previous case, 19 SC 167793. So for the purposes of this plea, we're moving forward on the accusation 23 SC 189043.
Okay. And Mr. Alexander, when I explain things to you, I'm not trying to talk down in any way, but if you don't know what null pros means, that means dismiss. So I'm understanding Ms. Hall to be saying, if this plea goes through on the document in front of you, the state's going to ask me to dismiss, which I will, the old indictment that has the more serious charges. Okay?
Okay.
Mr. Alexander, do you understand that you're charged with the following offenses: aggravated assault, false imprisonment, sexual battery, and 1 count of battery.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I understand.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges and this accusation, including any potential defenses?
I have.
Do you need more time to discuss this case with your attorney?
No,
Are you satisfied with his services?
I am.
Counsel, do you waive formal reading of the indictment?
I do.
Do you waive any defects in the indictment, including with respect to the defendant's name?
I do.
Mr. Alexander, have you been arrested on these charges?
Not on these new charges.
Say,
Not for the amended charges.
yeah, say that.
The original.
Yep.
the-
Well, that's a tricky question. Really what we're getting at is what you were originally charged for. And all this relates to an alleged interaction you had with a Ms. Morton. Were you ever arrested for the situation that was charged in the indictment and now in the accusation involving you and Ms. Morton?
Yes.
Has your attorney advised you of the minimum and maximum sentence of the charges that you're pleading to?
Yes.
Just to go over them with you on the record. Aggravated assault is 1 to 20 years to serve. False imprisonment is 1 to 10 years to serve. The sexual battery and battery charges are both 12 months to serve. You understand?
That's not the recommendation. That's just the maximum.
All right. Yes.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for false imprisonment, 10 years to serve, 10 years to serve with credit for time served. The aggravated assault, 15 years to serve 10 years, balance on probation, credit for time served. And for both misdemeanors, battery and sexual battery, both 12 months probation. Special condition that you have no contact with this victim, Ms. Morton, whether indirect or direct contact. And another special condition that you're banned from Fulton County, from entering Fulton County, unless you're coming for court proceedings or probation. Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on these charges and can run those sentences consecutively or one after another.
Put everything together or stack them. But he's gonna do it.
Is that for certain?
No, she's just like, he can change it if he wants to, but then you have the right to withdraw it at that time. You just have to understand that that's the possibility.
Yes.
You understand this is a guilty plea, which is permanently recorded on your criminal history.
Yes.
You understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts.
Yes.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
I understand.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
It is.
How do you plead to the charges of false imprisonment, aggravated assault, sexual battery, and battery in indictment 23 SC 189043?
Guilty, presuming the offer.
Are you pleading guilty because you have decided that it's in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and it places you in the same position as if you were convicted by a jury at trial?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
One more time.
I'm just asking you, are you doing this on your own free will and is it voluntary?
Yes.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes.
Thank you, Mr. Alexander. Your Honor, the state is aware of 2 prior convictions by the defendant, a robbery, false imprisonment, aggravated assault from 2008, and a more recent robbery from 2017, both out of state, one being in Florida. And Mr. Reeves, help me on the second one. I think it's Minnesota.
North Carolina.
North Carolina, okay.
Is that where we brought you from, Florida or North Carolina?
He was
Oklahoma.
in federal prison.
Oh, so is there a third conviction or one of these 2 is a federal?
The first one's a state conviction in Florida. The second one is a federal conviction out of North Carolina.
Got it. So it physically was in North Carolina, but it's a federal crime.
Yes, Your Honor.
Okay. Okay.
And Your Honor, had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on March the 4th, between March the 4th and the 5th of 2019, officers were called out to 360 Fair Road, PHARR, Atlanta, Georgia, that's in Fulton County. And they spoke with Miss Katrina Morton, that's the victim in this case. She spoke with officers and she told officers that she met the defendant the night before at a strip club. They end up going back to her home. There they had more drinks and they did eat together. Her roommate ended up leaving around 4 a.m., at which point she asked the defendant to leave. The defendant refused to leave, at which point it became physical. The defendant drug her from one room to another room, did force her down, pull her pants down, and have a non-consensual sex with her against her will. She did tell officers that this happened throughout the rest of the night. At some point, the defendant told her that he would kill her. She did tell the defendant that her roommate will be coming back soon, at which point the defendant advised her that he'll kill him as well. At some point around 7 a.m., the victim did notice that the defendant was sleeping and he was snoring, and at which point she got out the bed, put on some clothes, and ran out of her house. She ran down to the rent office where there she called 911. She actually had to call twice because they hadn't gotten there from the first call in a timely fashion for her. So she called the police twice. When they arrived, the defendant was still in the victim's bed. They did arrest him immediately. There were a little bit of a conversation with the defendant, but he did, after being read Miranda, he did invoke his rights to a lawyer, and he was charged accordingly. And that is all from the incident, Your Honor. I have spoken with this victim multiple times about this incident. She obviously was ready for trial. she does understand the decisions that she made that night, which would have made a trial a little difficult on her part. We do believe that she was violated that night, but looking at the facts of this case, we know that it would have been challenging in front of the jury. I did go to her with this reduction, and her standpoint is that she has been affected by what happened, and she does want the defendant to be accountable for what he did to her that night. However, she wasn't looking for a life sentence or even 25 years in a mandatory minimum. She just wanted him to pay for what he did and how it had affected her. She did not want to join the Zoom today. But if we do move forward with trial, she obviously would be there and be ready to testify. That is all from the state, Your Honor.
Thank you.
You're welcome.
Mr. Reeves, tell me what you want to tell me about Mr. Alexander. Start, please, by letting me know what his sentence is federally.
It's my understanding that his sentence is 10 years, and I believe his release date's supposed to be around 2029. Is that right?
28.
Usually do 85%. So, okay. All right.
And Your Honor, I've known Mr. Alexander since the outset of this case, and I've represented him since 2019. At the beginning, we did do our initial investigation. There's, as the state said, there are lots of issues in this case, which is a reason for the reduction. I've spoken with Mr. Alexander about this. And that's why when facing mandatory life in prison versus possibility of parole on a 10-year sentence, even with the issues, as Your Honor just heard, and I've explained to Mr. Alexander that, one witness can be sufficient for a conviction. And here they do have that victim witness. There were a lot of different issues I'm not going to go into at this point, but we do believe this is the best resolution for this case. I am asking that Your Honor accept the plea as negotiated. Myself and the state worked hard to kind of come to a resolution in this. And so I am asking that you accept that as tendered. I do want to just put on the record, I know it's up to the Department of Corrections as far as serve time, but I did just want to put on the record from my notes that Mr. Alexander was arrested on this case in March 5th of 2019. He was granted bond September 19th of 2019. So it's about 199 days or 6 months, 15 days. Then his bond was revoked as a result of the arrest in North Carolina, I believe by Your Honor, and that was June 4th of 2020. He's been continuously incarcerated since then. And since his bond was revoked, technically that's also on these charges. And that's about 3 years, 2 months, and 25 days. So, and I will preface this with, I'm an attorney, not a mathematician. So, but my math is approximately 3 years, 9 months, and 10 days is what Mr. Alexander has served as a result of these charges.
Okay. Appreciate you sharing that. Mr. Alexander, anything you want to add?
No, sir.
So you're entering this plea pursuant to the U.S. Supreme Court case of North Carolina versus Alford, which allows a trial judge to take a plea even when a defendant says it didn't happen like the state said it happened. I mean, clearly you were in the same apartment or condo with Ms. Morton because you got arrested there. But what else happened sounds like is a subject of dispute. What I'm hearing you say by taking an Alford plea is, I don't agree with all the allegations from Ms. Morton, but I, meaning you, would prefer this outcome of a negotiated plea, knowing what the sentence is going to look like, rather than going to trial and running the risk that the jury could credit her testimony. If Ms. Morton came in and told the jurors what she told the police, they could credit her testimony, and that's all they need. You might testify, there might be other evidence that is contrary to that, but if the jurors credited or believed Ms. Morton's testimony, that would be sufficient, because the testimony of a single witness is sufficient for them to find you guilty of rape or aggravated sodomy, maybe both, but it only need to be one. And then given your criminal situation, you're looking at life without parole. So I distill all that as Mr. Alexander would prefer this option, not an option he wants, but he'd prefer it to the risk of going to trial. Is that a fair summary of why you're taking an Alford plea?
Correct.
All right, then I'll accept it as an Alford plea. I now understand why you're in custody and how long that'll be. Ms. Hall, you believe that these reduced charges will not require Mr. Alexander to register as a sex offender?
That's correct, Your Honor.
Okay, I agree. Mr. Alexander, do you authorize, we're going to use that as the guilty plea?
Yes, Your Honor. Thanks.
Excellent. Okay. Do you waive any issues, Mr. Reeves, in working off a copy? That's not the original accusation, but we can use that as the official one that you and Mr. Alexander will sign?
Yes, Your Honor.
Okay. Mr. Alexander, by signing the accusation, you are indicating your Alford plea, and Mr. Reeves should write on there pursuant to NC versus Alford, if he's got that on there. Then you need to sign it as well if I'm going to accept your plea. Ms. Hall, may I or someone from my office sign this copy of the accusation on your behalf?
Yes, Your Honor.
All right. Mr. Alexander, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Voluntary, we've already covered. That means no one has forced you into this plea. You're not excited about it, but it's a decision you're making, having consulted with your lawyer and considered your options in this situation. Do you agree with me that this plea is voluntary?
I agree.
Okay. And the knowing plea just means that having had a chance to consult with your lawyer, you understand the things we've talked about, and at this point, you don't have any questions. Also correct?
Correct.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you are on probation, if you have a minor violation of your probation, you and probation sort that out. If it's a major violation, which would mean a new arrest or any evidence that you've contacted Ms. Morton, that comes back to me and I'll work through the consequences of that. Mr. Alexander, when you are released from whatever your last release is, whether it's your state case or your federal case, do you plan on living in Georgia or somewhere else?
Somewhere else.
Not the state of Georgia?
Not the state of Georgia.
Okay. What I'm going to do then is sentence you on count 1 to 10 years to serve, count 2, 15 years to serve 10, balance probated. Counts 3 and 4 will both be 12 months to serve. They'll all run concurrently with each other. So the total sentence is 15 years to serve 10 years, balance probated. You'll get credit for the time you served, whether it's the exact math of Mr. Reeves or not, TBD. That's not a decision any of us in this room makes. But I think you will get that credit. Special condition of probation number 1 is no contact with Ms. Morton, no direct contact, meaning you write her, text her, Instagram her, call her, or indirect contact. That means someone you both know you use as a conduit to get to her, whether you're saying, hey, I'm sorry, or when I get out, I'm going to break your arms. Anything on the spectrum is contact with her. If there's evidence of that, that'll cost you probably all your probation. And that would include parole. If you get out early on parole, that is revocable as well, subject to revocation. Second, since you don't plan on living in Georgia, I am going to ban you from every judicial circuit in Georgia except the Southern Judicial Circuit, which constitutes 5 counties in Georgia down at the southwestern corner of Georgia. If you like the Okefenokee Swamp, that's a great judicial circuit to be in. But it sounds like you're not planning on being in Georgia at all. So you don't have any reason to be in Fulton, Clayton, Cobb, Gwinnett, anything like that. You're going to be somewhere else. I think I've covered everything. I will dismiss, in other words, sign the null pros motion from Ms. Hall, case 19 SC 167793. And sign your final disposition, your sentence, in this new charge, and then we'll get you returned to federal custody. this sentence will run concurrently with your federal sentence. Do you have any questions about that last bit that I added after I last asked you whether you had any questions?
No,
Okay, it's okay if you got a question. I'm happy. I'm here to try to explain.
I kind of forgot my thoughts, but yeah.
Okay.
And Your Honor, excuse me for interrupting. This is victim witness advocate Latika Montgomery.
Hello, Ms. Montgomery.
Good afternoon, Judge. How are you?
I'm okay.
Again, sorry for interrupting. I did hear from the victim and I received the statement a little bit late during the plea, and she changed her mind. She did want to be heard, and I will speak on her behalf whenever you have time, Judge.
Time right now. I'm sorry, I didn't mean to ignore you. I saw you were on here. We often have victim advocates on. I was relying on Ms. Hall's representation, but it sounds like there's news.
No, she didn't. She didn't know. I just sent her the message. So I apologize for, it coming in so late. Thank you for allowing the victim to be heard. Ms. Kendra Morton writes, "It grieves me that I must find the words to adequately depict how deeply this one moment in life has affected me. I could never have imagined that my body and my peace would be violated. Today, I feel broken. The man responsible for this trauma, in my opinion, is being given a slap on the wrist when I'm forced to wear a crown of thorns on my head. I have been shamed as a woman for inviting someone into my space when it seems to overshadow his deliberate, hurtful, and undesired abuse to my body. I am hurt that he is not receiving the maximum penalty while also carrying feelings of disappointment, hopelessness, brokenness, and fear that someday this reality will be the source of another woman's pain. This trauma has impacted every aspect of my life. The gut-wrenching memory of being forced to be the subject of someone's pleasure without my consent haunts me. Throughout my days, flashes of this moment overtake me, and immediately I am confronted with the realization that I too have become another statistic, a Black woman violated, undervalued, underserved, and left with fear and uncertainty. How do I process this level of pain? How do I grieve the most sacred part of my body being forcibly shared with a monstrosity of a human being? I weep from the depths of my soul. I scream inwardly and silently as I live with the trauma that rings loudly in my mind. How do I deal? Words are inadequate as there is nothing that I could ever say that gives light to the depths of the anger and sadness. I will always mourn the person I was before this night. I have become a shell of myself. I look in the mirror and the woman I see is far from me. I want justice. I want to believe that my pain is worth more than a settlement. I want to know that I am protected, and this blatant disregard for my choice to say no has not been heard, and my wounds are not in vain. Thank you.
Thank you, Ms. Montgomery. We have on this call something that just says iPhone. Is that Ms. Morton? Did she join us, Ms. Montgomery?
Miss Morton did join. I'm not sure if she is just under iPhone.
That's fine. I'm not asking her to show herself or do anything more than that. It's important for me to understand who's joined the Zoom call. And you have given voice to her powerful words. I just wanted to understand if we knew who iPhone was. Thank you for sharing that. And by no means did I mean to try to exclude that from the proceedings. It sounds like Ms. Hall wasn't aware that the impact statement had come in either.
No, she was not, Your Honor. And
Okay.
I know you weren't. I know you weren't trying to exclude it. That's why I figured I would just jump in when I found a moment. Thank you for allowing me to speak.
No, you entitled to, and important that I hear that. And I have this to add. We are where we are because life is complicated, and what happened to Ms. Morton should happen to no one. I don't feel that there was a devaluing of anyone or anything. Ms. Hall is an expert and seasoned and caring prosecutor. And if she has concluded that this is a reasonable outcome, that's the product of weighing all of the many elements that go into a complicated prosecution like this. Mr. Alexander is not getting a slap on the wrist. He's not getting life without parole either. Ms. Morton is not having to come into court and sit in front of 14 strangers and talk about one of the most intimate ways someone can be violated. There are trade-offs, and none of this is meant to make Ms. Morton feel better about what happened to her. That's not my point. I just don't want her to conclude that she wasn't heard and that her pain was somehow devalued. I trust that Mr. Reeves and Ms. Hall thought long and hard about the best way to resolve this, because of course another scenario is that there's a trial. Ms. Morton has to go through the trauma of that, and a jury says guilty, but a mistake was made, and a court of appeals reverses the conviction, and then we start all over again. And this is certainty. There's no reversal of a guilty plea. Mr. Alexander goes his way for many years, and Ms. Morton is able to go her way with some peace of mind, knowing that Mr. Alexander is paying a price for the allegations in this case. So with that, Mr. Reeves, anything else on behalf of your client?
No, Your Honor.
Ms. Hall, anything else on behalf of the state?
Nothing further from state, Your Honor.
Okay. Mr. Alexander, I need to do a little bit of paperwork, but once that's complete, we'll let the marshals know, and I suspect you'll be returned to federal custody in due course. If you find yourself stuck here, reach out to Mr. Reeves so he can let me know that somehow that return paperwork didn't get filled out. Okay. All right. Thank you, everyone. And thank you again, Ms. Montgomery, for stepping in.
Thank you, Your
You're
Honor.
welcome, Judge. You have a great afternoon.
You too.
Thank you, Judge.
All right.
So what's up with, okay, I need to hop on another Zoom for 5 minutes to tell them that this has happened. And let's get all the, I'll give this card to, you have their numbers? You've called them already, or you will? Okay, good. Here comes Ms. Phelan. Thanks.
Oh, thank you. It's a pleasure. All right, yes, we thank you. Thank you. Great job. Thank you.
Yeah. Yeah. I just have to preserve.
Absolutely, we understand. It's okay. Don't worry about it. I got the exhibits closed out. I don't need it. Is there still a Zoom? Yeah. I'm not in the Zoom anymore. I'll go back in. Like how Pete calls me by my last name. What is it? Pete Anthony. He like fluctuates between Julian and Jordan. Yeah. This is the chair that sings. I think both of them sing, to be honest with you.
Court come to order, remain seated.
Which one of you said that? You, there, all right, well said. Okay, Ms. Rivers, are you ready? We'll bring Mr. Higginsbottom out in just a second. There were two juror procedural questions that I'll share with you in a second, and we also have a verdict. Anything we need to talk about before Mr. Higginsbottom comes out?
No, Your Honor.
Okay, Ms. Feely, if it's a guilty verdict, sentencing today, not today.
I'm fine with it.
Okay, I'm prefer to do it today. what we'll do is take the verdict. If it is a guilty verdict, sentencing will be today, but it will be at 4:30. I have a 4 o'clock meeting with a couple other judges, and I'll get beat up if I don't go to that. So we'll take the verdict. I'll chat with the jurors briefly, then they can interact with you all if they want to, while I go to this session. And then we would do sentencing if that's what the verdict calls for. Okay, let's bring Mr. Higginsbottom out, please. Ms. Rivers, are you ready? Okay, we're back on the record in State versus Higginsbottom. We have a verdict. I'll bring the jurors out in a minute. Before then, before that happens, Deputy Gordon delivered one note card with 2 questions on it. Question 1, are the identities of the juror available to the public? Question 2, is the guilty verdict signed by the foreperson publicly available? The answer to question 1 is no. There is a juror, what do we call that form? Juror usage report that actually lists the name only of every juror. That has to be filed in the docket for appellate purposes, potentially, but that's actually not publicly viewable. The answer is yes to the second. The verdict form will be made publicly available. So I didn't answer this for the jurors. I didn't bring you all back in. I was taking a plea in another case, and Deputy Gordon informed me that they were continuing their deliberations, even though they didn't have answers to these questions. So I will address that with them. Ms. Feely, do you want me to do that before or after we all receive the verdict?
Either one.
You don't care? Okay. Do you have an opinion, Mr. Adkins?
Your Honor, the state's fine with addressing it within or after the verdict.
Okay, that's the plan. Then let's bring the jurors in, please. No, those 2 stay there.
Like it needed updating and then the update started and
Did you do that yourself, or they said this is what he said?
no, I was able to sign on further than what I did last time. So I
Okay.
know you did do something.
Okay. Well, I think tomorrow they need to spend a day in here giving us a tech. I don't know, what would be like a spa session for the computers.
All right, juror.
You all can be seated. Thank you. It's like, wait, there are 2 empty chairs, but there's supposed to be 2 empty chairs right now. All right, ladies and gentlemen, it's my understanding that you all have reached a verdict. Are you the foreperson? Okay, can you pass the verdict to Deputy Gordon, please? All right. Okay. So what I need you to do as foreperson is to publish the verdict, which means you're going to read it into the record. You can just start with count one, say count one, we the jury find whatever is in the verdict form. Please, if you would, just so it's easier for the court reporter to hear you.
The jury find the defendant on count one guilty. The jury find the defendant count two, child molestation, guilty. The jury find the defendant on count three, child molestation, guilty. And the jury find the defendant guilty on four, child molestation.
And you signed, it appeared to me, but I want to confirm,
Yes.
that's your signature and your printed name and
Yes.
date. Okay, Deputy Gordon, if you would share the verdict form, please, with Mr. Jordan and then Ms. Feely. Mr. Jordan, do you have any objections to the form of the verdict?
No objection, Your Honor.
Ms. Feely?
No objection as to form.
Okay. Mr. Jordan, anything else before I dismiss the jury?
Your Honor, Your Honor, we would like to speak with the jurors if they would so desire.
Okay. Ms. Feely, anything before I dismiss the jury?
No.
Okay. Ladies and gentlemen, in just a moment, you're going to go back to the jury room. I'm going to come back there and thank you for your service. Let's talk to you about a couple things. And I'll have those letters you asked about that will vouch for your presence here Monday through, today's Thursday, Monday through Thursday. It won't cover you tomorrow. We'll reunite you with the alternates so they can learn about what you did. When we're done with that interaction, you can leave if you've got someplace you need to be. But it may also be that you are willing to give feedback to the lawyers. It would be just the lawyers who are sitting in the courtroom. They often learn from getting that feedback, but that's purely optional. And we'll talk about that in there. You don't need to commit one way or the other out here. So I will see you in the jury room in about a minute. But before you go, on behalf of everyone involved, because the lawyers don't get to speak directly to you unless they're given their opening or their closing, thank you for your time. We couldn't have reached the closure that this verdict brings without the 12 of you and the 2 of them doing what you did for the last 4 days. So I appreciate your service. The people of Fulton County appreciate your service. I'll see you in just a minute.
All right, adjourned.
All right, before Mr. Higginsbottom goes back there, we'll reconvene at 4:30, this courtroom. We'll leave the Zoom. I'll pause it for right now. But we'll return for a sentencing hearing.
Your Honor, may I ask one specific thing related to the 4:30 sentencing? Would the court permit Antoinette to appear on Zoom to speak?
Of course.
Okay, thank you, Your Honor. Thank you, Your Honor.
All right, Ms. Feely, I know that means you got to stick around for a little while, but 4:30 is okay? Yes. Okay, all right, we'll see everyone then.
We're a family of five, three beautiful
There we go. All right, Ms. Feely, are you ready for Mr. Higginsbottom?
Yes.
Great. I will, let's bring him out, please. Ms. Rivers, I'm going to give you what will be courts 3. That was the one juror card. All right, Ms. Rivers, are you ready? Okay, we are turning to the sentencing in State versus Higginsbottom. A jury returned a verdict of guilty on all counts. I have made as courts exhibit 3 the juror questions that came up during their deliberations, which related to whether their names would be publicly available. I answered those questions for them when I was excusing them after we took their verdict, but I'm making that card part of the record. So we are turning to sentencing right now. Do you know where the evidence went? You've got it. Oh, it's back in the back. Okay. Nope. I'll be all right. I'll just pull out the indictment here. Okay. Mr. Jordan, are you handling sentencing or is Mr. Atkins?
Mr. Atkins, Your Honor.
All right, Mr. Atkins. My understanding, given, and I assume you're going to tender a certified copy of the conviction in a moment, that there are not a whole lot of sentencing options. At least count 1 will require a sentence of life with the possibility of parole. Counts 2 through 4 are all a 1 to 20. There has to be a split sentence based on the peculiar sentencing requirements of child molestation, so that there'd actually be a period of probation. Even if I ran them concurrently with the life sentence, I could run them consecutive, so that in theory, there's probation out there. And I don't know that there is any merger here. It doesn't seem like it. I think there is a unique element in each of the 4 offenses. But I preview all that just so you don't need to argue in that direction. If you agree, if you disagree, and Ms. Feely may disagree, I'll hear the disagreement side. But I think that's how sentencing is likely going to have to play out. With that, I'm going to turn it over to you.
Thank you, Your Honor.
Sure.
The state would like to put on the record that on May 8, 2023, we did file pursuant to 17-10-7 alpha recidivist. And the state would at this time, I believe it should be marked as State's Exhibit 30, because the last admitted exhibit at trial was 29.
And so we're clear on the record. I don't know that 29 was ever admitted, but it was marked, identified, played for the jury. So yes, you're on 30.
Thank you, Your Honor. The state at this time, and have showed this to defense counsel, would move to admit pursuant to a certified conviction, business record certification, the grand larceny and perjury charge from Stafford, Virginia on April 12th of 1999, which was clerk number CR 980000392, Your Honor.
Okay. Ms. Feely, any objection to the admission of States 30?
We don't have a legal objection to it.
Okay. And that's what I'm usually asking for, is legal objections as opposed to policy. Okay, states 30 is admitted.
Your Honor, the state does agree with this honorable court regarding because of 1710(7) alpha, the maximum for aggravated child molestation is life. And because a life sentence cannot be probated as a matter of law, the court's discretion on count one is, it must be a life sentence legally speaking, Your Honor. And that is what the state would request. The state also agrees with this honorable court that because of the requirements of 1710 6.2, which child molestations count 2, 3, and 4 must comply with, that the state would ask for count 2 to be count 2 and 3 to be consecutive to one another, which would be a total of 40 years, and for count 4 to be 19 years consecutive to count 3 with the final year of probation to comply with the statute. 1710.6.2, Your Honor.
Okay, I was recently reading about this, not because of this case, but because of a sentence I'm trying to get the clerk's office to accept. Do I not need to give a term of probation for each of the 3 counts? The way you understand 17, 7, 6.2, whatever it is, 6.2, only if I am stacking them, running them consecutive, only the terminus, the final of the consecutive counts requires a term of probation.
Yes, Your Honor, that is the state's understanding. I was trying to look as I'm speaking. That is my understanding, Your Honor. Because when a court, and this is from 1710 6.2 subsection Bravo, it says, however, that when the court imposes consecutive sentences for sexual offenses, the requirement that the court impose a probated sentence of at least 1 year shall only apply to the final consecutive sentence imposed.
Oh, that couldn't be clearer. Okay, that's impressively clear for a sentencing statute.
Yes, Your Honor. So to be clear, the state's recommendation, and we'll explain why in a minute, but for purposes of sentencing, is life on count 1, aggravated child molestation.
Hold on one second. I'm trying to find the language you read. Ah, here it is. Okay, so should I follow your recommendation? That is a legal sentence. So you're basically asking for life plus 59 and 1 year of probation.
Correct, Your Honor.
Got it. Okay.
The state would also, as a matter of law, the state has sex offender special conditions of probation, additional conditions of probation for electronic monitoring, mandatory submissions for polygraph as a condition of probation, and restrictions for computer use. The state, although count 1 is legally a life sentence, the state does feel like the correct course of action legally is that these documents should be filled out and that the defendant, as a convicted of a sexual offense, should have to complete these and have these officially part of his sentence.
Okay, let me ask Ms. Tucson a question. She's joined us from the Department of Community Supervision. Ms. Tucson, do you know how the sex offender registry works for someone who is on parole? Meaning, if in the end, what I sentenced Mr. Higginsbottom to is life, and he paroles out at year 34, he will be on parole for the rest of his life because he got a life sentence, but he's not on probation, but this is a sex offense. Would Mr. Higginsbottom, he'd be under your office's supervision, would he be required to register because he is a sex offender parolee rather than probation? Does that question make sense, Ms. Tucson?
Yes, Judge. Basically, whenever it is in the reporting instructions, whether it is parole or probation, because it's all in one now, if it is a requirement, then they will make sure he does register.
Okay, thank you. Anything else?
Your Honor, a couple of things, Your Honor, that Antoinette is listening on the Zoom. I have spoken with her.
I see her.
Yes, Your Honor. She has, the latest that she had informed me, and I told her if her position changes, please let me know, is that I was going to speak on her and Serenity's behalf. And I'm paraphrasing, but what Serenity had wanted me to share with this honorable court.
Well, before you do any of that, let me just, I'm not going to require Antoinette Mathis to say anything at all. Can you just give me a thumbs up, Ms. Mathis, if you would prefer that Mr. Adkins speak for you? Okay, I'm going to let him do that. If you change your mind, ma'am, you have an absolute right to be heard here as your sister's representative, but it's perfectly appropriate to let Mr. Adkins do the speaking. And that's what we'll do unless you change your mind, come off mute and say, wait, you need to hear from me as well. But I appreciate you joining us, okay? All right, she's nodded and she did give the thumbs up, which means you are the spokesperson, Mr. Adkins.
Thank you, Your Honor. And what Serenity wanted to make this court clear of is that she feels relieved that he will not be getting out of prison. Because I have explained to her, if convicted, it would be a life sentence. And she also wanted to be known that she wants him to pay for what he did to her. I will also explain to the court for the recommendation by the state that when I first met with Serenity and talked to her and tried to explain to her, make sure she understands what some possibilities could be, she was very inquisitive about a sentence, and she was very inquisitive with me about him not doing this to someone else. And so I wanted to implore to the court that the effect on Serenity was quite apparent from her testimony, but also from my conversations with her and from my conversations in the testimony of Ms. Livingston and Ms. Pendergrass, that it has had a significant mental and emotional toll. I won't put all the details in the records, but there is, counseling and therapy that has gone along with this. That this went on for a number of years, and it was withheld inside of her, and the effect of that, as this court knows, is quite significant on a child. And so the state would like to make it clear that Serenity's courage is what led us to this position. And the state feels that, and I'm not going to read these, but there is a lot of good preambles in both the child molestation statute and 1710 6.2 about the dangerousness and effects of sexual predators in the community. And the state feels that this sentence recommended by the state is appropriate, given that this happened over a number of years, multiple times with someone that should be a support network for Serenity, and it happened in her home. And so with nowhere to turn, nowhere to go, it is extremely sad, and it is extremely egregious in the state's position that he would take advantage of that position of authority of a child, and instead of treat her correctly, he molested her, Your Honor. And I know that this court heard the trial and testimony as well as aware of the facts and evidence, but the state strongly recommends the sentence recommended to the court for the reasons articulated, Your Honor.
All right, thank you, Mr. Adkins. Ms. Feely.
Thank you, Your Honor. We do believe that there is a merger issue with the counts 2 through 4. Unfortunately, I did not bring my laptop, but I'm trying to get some more information to give to the court about that. But I do think it's all one transaction, one date on those 3. And so even though they allege different elements in each of the 3, I think they still would merge.
Sort of like if it were an armed robbery and I took your phone and your laptop, and that was one armed robbery, and you were charged with armed robbery for the laptop as well as for the phone.
That's right.
Okay. I don't know the answer, but I want to get it right. So I'll do a little looking while you're talking.
Thank you. We have also read the statute. We are asking the court for what the court can give, which is life. In terms of what to do with the probation, we leave that to the court's discretion. I don't know how the court would want to style the sentence. But Mr. Higginsbottom is 53 years old. He's originally from DC. That's where his family is. He has an adult daughter. The most striking thing about this situation is his only criminal history at all is from 1999 out of Virginia, and it is the larceny conviction that has been tendered into evidence. Unfortunately, that triggers the subsection A recidivist, and we understand that, but that conviction is his only conviction. No other felony convictions, nothing violent, nothing of sexual nature, no guns, no drugs, nothing. And he's 53 years of age. So practically speaking, it may not make much difference at 53 years of age, but we would ask the court to consider his record and consider giving him the mandatory minimum and no more.
Okay. Mr. Higginsbottom, I heard through Mr. Adkins from Serenity and the part of her family that's supporting her, and I should hear from her and her family as the victim in this case. But I also need to give you an opportunity to be heard if there's anything you want to say. You don't have to say anything at all, but you have a right to what we call allocute, which is speak your piece if there's anything you want to say. But much like with testifying, you also have the right to say, nope, I don't have anything I want to add. But this is your chance if there's something you want to say.
There's nothing like that.
Okay. Give me one moment to look at the case of Scott versus State, which is dealing with multiple counts of child molestation. Don't know if it's right on point. It is right on point. Let's see what they decided. So in Scott versus State, which is 306 Georgia 507 from about 4 years ago, almost to the day, a defendant was convicted of 4 counts of child molestation, 3 of which related to the same incident. 1 count involved Scott touching the victim. It's going to sound familiar. The 3 body parts that are alleged in counts 2, 3, and 4 are counts 2, 3, and 4 in the Scott indictment. He was found guilty of all of those, and he was sentenced consecutively for those 3 counts. Scott said that they should have merged because it was one interrupted act of child molestation. The Court of Appeals rejected that. It went on, they used the required evidence test. Well, to prove count 2, it was touching this body part. Count 3, it was a different body part. Those aren't the same, so there's no merger. The Supreme Court said that merger can arise when there are multiple counts of the same crime. And you have to work through the unit of prosecution. Just give me a second, because they didn't rule. They sent it back to the poor trial court to say, fix this, meaning identify the applicable unit of prosecution. Okay. Mr. Adkins, any thoughts about how I ought to apply Scott to this situation? Or did you find a different case post-Scott that says, you know what, the unit of prosecution for counts 2, 3, and 4 is an incident? And in the same way that if hypothetically a defendant touched a victim in an inappropriate place 4 times over the course of 10 minutes, that's not 4 molestations. That is an act of molestation. And 4 times in one place versus 4 times in 4 different places. Is that really 4 different crimes or 1 crime because it's 1 incident?
So, Your Honor, the state would also, to start, would like to highlight OCGA 1664, which is child molestation, aggravated child molestation, specifically subsection A1, which says, and I will read verbatim, for purposes of this code section, when a person does an immoral or indecent act involving touch of any child under the age of 16 years with the intent to arouse or satisfy the sexual desires of the child or that person, any such person touches such child in multiple areas of such child's body, the touching of each area shall constitute a separate offense of child molestation.
Where did you say this is?
OCGA 1664, Your Honor,
I'm there.
and subsection A.1.
Ah, okay.
And Your Honor, just to kind of stand upon that, it's the state's position that the unit of prosecution is set forth in the statute, which is significant. And also, Your Honor, with dates not being material, the state also believes that there is, on child molestation counts, evidence that they occurred on multiple occasions, but that's a separate route, Your Honor. The state does not believe that they merge as a matter of law, for one, Your Honor.
Okay. Trying to see when A1 was added, if it was after Scott. Yeah, A1 was added in 2022. Okay. I'm not saying it was directly in response to Scott, but Scott posed the question to trial courts, what do we do with the scenario I think A1 describes? Okay, well, I'm going to pronounce the sentence. The sentence that I'm going to impose in some ways makes this debate moot, but it's going to be no merger. And so that may be an appellate issue that needs to be explored. My guess is if I have 15 minutes without you all needing to be in other places, we'd find a case that reconciles Scott with A.1.
Can I put one more side on the record, Your Honor?
Yes.
So the Scott case was remanded, and it was actually Lauren Chubo's case, and the appeals court decided it in 356 Georgia App 152, a case from 2020. And in that case, it was.
They merged?
Yes.
Can you give me that site again?
356 Georgia App 152.
152.
2020 case.
Judge Ellerby's case. Just seeing if the Court of Appeal, the 356 case had been distinguished in any way. It was in one case, but it was because the defendant was trying to say it was all one interrupted series of events, and it wasn't. Okay, well, we'll see how this plays out. It's an easy fix if that part gets reversed on appeal or remanded on appeal. Mr. Higginsbottom, your lawyer was a very effective advocate on your part, and one of the things she highlighted was the lack of forensic evidence that all we had to go by, all the jury had to go by, was the testimony of poor little Serenity. And it was corroborated through statements she made to others, but there wasn't much physical corroboration because there wasn't a lot of physical evidence. Serenity Mathis is not someone who bears physical scars of molestation. There are molestations that are even more horrific, and the physical evidence is a sexually transmitted disease that the child gets, or burn marks or cuts or tears. And fortunately, it's a very, very thin silver lining. That's not the type of scar that Serenity Mathis bears, but invisible scars can be far more permanent and hurtful and harmful than physical scars. And I think we all saw how your conduct has affected that little girl who already has any number of challenges that she's going to need to work through. This was something that ought never to happen to anyone, but for a little girl who had these other obstacles put in her way, it's inexcusable. I'm sentencing you on count 1 to the only sentence I can impose, but I'm very comfortable with the sentence, which is a sentence of life. It is a sentence for which you are eligible for parole. Counts 2 through 4 will, I guess to make it right, counts 2 through 4 will all be 20 years to serve 19 with the balance probated. They'll all run concurrently with each other and concurrently with count 1. So your total sentence is a sentence of life. You're 53 years old. You've done less than a year in custody. You won't be eligible for parole until you are in your early 80s. Whatever you were going to do to kids again isn't going to happen when you're at that age if you make it through 30 years in the Department of Corrections. So I'm not particularly worried about your next victim. You might want to worry about how prison's going to go for you. But that's a different set of concerns that you bring upon yourself through the decisions you made and what you did to Serenity. Should you be paroled or somehow released while you're still living, you are banished from Georgia, except for the Southern Circuit, which is the southwestern portion of the state of Georgia. You won't be in the metropolitan Atlanta area. So if Serenity and her sister stay here, they will be safe from you. You will need to be somewhere else. I do believe you'll be required to register as a sex offender should you be paroled or released for probation. That brings a host of requirements that you'll need to navigate in terms of where you can live, the type of work you could do. But again, based on the Board of Pardons and Parole's current policy, we're talking about you being in your 80s. So I don't know that employment is going to be something that you will be having to work through. You have the right to appeal your sentence and conviction. You can do that in several ways. The natural first step is to file a motion for new trial. The other option you have in terms of a direct appeal is to say, forget about the new trial. I want to go straight to the Court of Appeals. That's what we call a direct appeal. You have the right to have an attorney help you with either the motion for new trial or the direct appeal or both. And you can actually do both. A motion for new trial, if denied, would still leave that direct appeal to the Court of Appeals. You have 30 days from today to file either a motion for new trial or a notice of appeal. And I'm going to ask Ms. Feely to handle that initial step for you. And then she's going to ask to withdraw so that you get a fresh set of eyes to look at the transcript of this case, because that lawyer will be evaluating the prosecutor's performance, your lawyer's performance, and mine in looking for error that may have occurred. If it's a motion for new trial, that's argued in front of me. You will be here for that. You have a right to be present, at least virtually, if not in person, for the motion for new trial. If I grant that, it means what it says. You get a trial again. You'd come back here, Serenity would take the stand again, and we do this trial all over, hoping to avoid whatever errors were made by me, by your lawyer, or by whomever. If I deny the motion for new trial, then that same lawyer who helped you with the motion for new trial would help you with your direct appeal. That's all paper-based. You don't go to court for that. That's argued in front of the Court of Appeals. And in theory, it could go to the Supreme Court, depending on how that played out. But with none of the appellate parts are you directly involved in terms of showing up in court. But you'll have a lawyer appointed to represent you for all of that. Your other route is what we call a habeas challenge, and that is a civil action. You don't have the right for a lawyer for that. but you don't need to worry about exercising your habeas rights until 4 years after your conviction becomes final. And that's not 4 years from today. It would be 4 years should you appeal until your appellate rights have been exhausted. So that 4-year clock's not going to run for a little bit. But if you do mount what we call a collateral attack, that's this habeas challenge, unless you can afford an attorney, that's something you have to do on your own. I just laid a lot on you in terms of your appellate rights. The most immediate thing is for you and Ms. Feely to talk about whether you want her to file either a motion for new trial, a placeholder one, it's a single piece of paper, or a notice of appeal. So I encourage you to have that discussion with Ms. Feely. I can't make you do it, but if you direct her to do one of those two things, she will do that, and then she'll withdraw from the case. Ms. Feely, will you have that discussion with Mr. Higginsbottom?
Yes, sir.
Mr. Higginsbottom, do you feel like I've explained adequately at this initial point what your appellate rights are? Okay. Mr. Adkins, anything else you think we need to cover on the record before we close out the trial level proceedings for State versus Higginsbottom?
Your Honor, the only thing is I have hard copies I could provide to the court is just the special conditions and sex offender paperwork.
So I know what they are. Because Mr. Higginsbottom is not looking at needing to register for 29 years and 3 months, those may change. And I'm going to let the Department of Corrections work through that with him.
Yes, Your Honor.
Okay. Ms. Feely, anything else on behalf of Mr. Higginsbottom? Thank you for your work on his behalf. We are adjourned.
Thank you, Your Honor.
Ms. Mathis, I'm going to shut down the Zoom call now. If you have any questions about what happened today or during the trial, reach out to the victim advocate you've been working with, okay? All right. Thank you for joining us.